This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hey everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, reading through the Menendez brothers' trial, the second trial. So we are going to continue today with Dr. John Wilson's direct testimony. They're going to complete the direct testimony today, and then we'll get a little portion of his cross before they go to lunch, and then we'll cut for this episode, and next episode we'll get the second half of the day. So, just wanted to let you guys know what's going on right now. I would like to thank my founding justice insiders. So that would be Toyota Girl 67, SLB 29488. May the force be with you 4313, Jessica Wienand 6079, Mrs. Apples 2007, Butler 89833, Brooke JF, Jen P 773, Boom Chicka Wow Wow 1, Kendall B 5757, Carly 0406, O Ashley 83, True Crime Debates, Sandy South 5706, Chickenhead 33, always makes me laugh, Nicoti O Nerotini, I think is how you say it. That's So Nelly, Julie E 6007, 1-800-FRAUDBUSTERS, Bezo Jones, and Hannah Banana Bandana 23. Thank you all for being founding Justice Insiders. You came on as a Justice Insider early on, so thank you very much. We also have additionally, Justice Insiders who unfortunately didn't make the cutoff for the founding Justice Insiders, but they are still supporters, and still I would like to thank Lainey Jane 91, Couch Potato Pro, and Tech Vibe _42. Thank you all for being Justice Inside members. You can also be Justice Insiders if you go to the memberships tab and sign up there. There's 2 different tiers and all kinds of different perks. All right, so let us continue on with Dr. John Wilson's testimony, and we're beginning the day of Tuesday, January 23rd, 1996. And the Honorable Stanley Weisberg is presiding, and he says the participants are present. We will have the jury out, please. Ms. Abramson says, "Good morning, Your Honor." The court says, "Good morning." The jury enters. And now the court says, "The jury's in the jury box. Good morning, ladies and gentlemen. We are ready to resume with the trial. The witness is on the witness stand. State your name again for the record." And he does. And the court reminds him he's still under oath and tells Ms. Abramson she can continue with the direct examination. Ms. Abramson says, "Thank you." Dr. Wilson, you have read the testimony that Erik Menendez gave in this trial, correct? Correct. And you have both the direct and the cross-examination. Correct. Have you studied rather carefully the testimony that he gave about the events starting on Sunday, August 13th through Sunday, August 20th? Yes. And in reading his testimony, were you looking at it from the perspective of a PTSD analysis? Yes. Did you form an opinion as to whether or not the fact that he suffered from post-traumatic stress disorder had an impact upon his perceptions during that week, his emotional and cognitive reactions that week, and his actions that week? Yes, I did. And what was your opinion? My opinion is that his post-traumatic stress disorder affected each of those areas of psychological functioning. Over the course of that week? Over the course of the entire week, that's correct. Were there events that occurred that week and some perceptions and reactions that he reported that were classic PTSD reactions? Yes. Now, what I'd like to do is go through the rest of those days and ask you to identify which events, which perceptions, which reactions are consistent with your diagnosis of PTSD and why, okay? Sure, says the witness. Miss Abramson says, let's return, if we can, to what we were talking about yesterday, which was Thursday of that week. I think you have already testified to the significance of his report of his contact with his mother in a general sense. Let's back up to this, though. Assuming, for the sake of the next questions, that Erik Menendez's testimony is accurately reporting the facts concerning the Thursday night, you recall that aspect of his testimony, do you not? Where he talked about returning home late at night, having avoided the conversation between his brother and his father? Yes. You recall him testifying that he went into his bedroom and was confronted there by his father. That's correct. And you recall the details of that confrontation? Yes. The anger and the threats? Yes. And the assault? Yes. Now, what significance from the standpoint of your diagnosis of post-traumatic stress disorder were the events that you reported concerning that confrontation with his father? The clinical significance of the confrontation with his father on Thursday night in terms of post-traumatic stress disorder is, number one, that the secret has now been revealed. Objection, argumentative, improper expert opinion, says Mr. Khan. The court says sustained, the answer stricken. Okay. Ms. Amerson says, well, what impact from a PTS standpoint would the revelation of a secret have? Improper foundation, improper expert opinion, says Mr. Khan. The court says, again, it refers to what, if any, mental state the defendant testified about in his testimony. Yes, says Ms. Abramson. The court says, and this testimony about this witness's testimony about that. Ms. Abramson says, let me catch that, Your Honor. I'm not asking for your independent opinion of what he should have thought or should have felt or would have thought or would have felt, but based on what he testified he did feel, and you have that in mind, do you not? Yes. He testified, did he not, that he was terrified by this confrontation? That's correct. That he believed that the threat that had been repeated to him many times, was going to be actualized, was going to happen? Correct. All right, my question to you is, from PTSD standpoint, given his testimony, what's the significance of objection, vague, and irrelevant, sustained? She didn't even ask the question. Your Honor, I need to be heard. The court says, it's unclear what you mean by significance. Ms. Amerson says, in his testimony that he was terrified, is his testimony that he was terrified consistent with someone who has PTSD stemming from abuse from the person who is making such a threat? It is. Is his reaction in which he believes he is going to be killed consistent with how people with PTSD react emotionally to the perception of a threat of repeated trauma such as was testified to here? Yes. Now, do people with PTSD, when they react in this hyper-aroused way, are they reacting merely to the current threat, or does the whole history of threat enter into it? Objection, irrelevant. Rephrase the question. Ms. Abramson says, you indicated that Erik Menendez suffers from PTSD, and one of his symptoms is the re-experiencing of the trauma, the constantly living with the trauma. That's correct. Is his testimony concerning how fearful he was as a result of this confrontation consistent with someone who is experiencing not only the immediate threat, but a reliving of all the previous threats? It is. Now, with respect to the event that he testified followed that confrontation, the event that followed that confrontation, according to his testimony, first of all, the exchange of information with his mother. Strike that. You are familiar with Erik Menendez's testimony that as a result of the exchange of information with her in the den, her angry reaction, her angry words at the guest house, and her statements when she is asked why she didn't ever do anything to stop the molestation, that no one ever helped her, that she is basically the victim in the family, and her turning on her sons and saying, I hate you, I wish you were never born. That segment of Erik Menendez's testimony, do you have that in mind? Yes. And you recall Erik Menendez's testimony that as a sequence of what she said and how she behaved, he feared that his mother would kill him. Do you remember that? Yes. Now, from a PTS standpoint, from the diagnosis of PTSD you made with respect to Erik Menendez and the specific symptoms and the focus of or the trauma leading to it, what significance from a PTSD analysis is his statement that he feared that his mother would kill him? Objection, vague, says Mr. Khan. The court says, again, it's vague as to what is meant by significance. Ms. Abramson says, do you have an opinion as to whether or not that fear was influenced by the fact that he suffered from PTSD? Yes, I do. And what is that opinion? My opinion is that that fear is very much, that fear was very much affected by his PTSD. How? It was affected by his PTSD because he had intense anxiety, hyperarousal connected with the traumatic experiences of the past, and now this fear becomes intensified. Mr. Khan says objection, improper opinion, which I don't think it is. And the court says the last answer, the fear becomes intensified, is stricken. The rest of the answer will stand. That's literally what happens, Judge. You can't deny the science. Like, why are we trying so hard to keep this out that that the fear was intense? Ms. Abramson says typically do fears that people with PTSD experience become intensified with the piling on of additional threatening when they perceive as additional threatening information? Mr. Khan says objection, irrelevant in Penal Code 29. Overruled, you can answer the question. The witness says the answer is yes. Ms. Abramson asks, and assuming for the sake of these questions that what Erik Menendez said about this exchange was true and that this heightened his fear, is that consistent with the way that people with PTSD would continue to ascend in levels of fear with additional cue of threat? Yes. Nailed it. This girl gets the question in when she had several objections. She finally got it in. All right, now focusing your attention of the event that transpired immediately after the confrontation with his mother at the guest house and after she leaves, do you remember Erik Menendez's testimony that at that point he believed that his parents were going to kill him then? Yes. And he went and he locked the door and looked out the main house to see if they were coming. Yes. Is that reaction in a state of height? Well, first of all, did he describe a state of mind consistent with the PTSD definition of hyperarousal? Yes. And in a hyperaroused state, when someone has, I am just going to keep using PTSD rather than, he says. With PTSD, is the fear that the threat is about to be realized a typical hyperaroused feeling? It is. Now, you recall Mr. Menendez's testimony that following the locking of the door, he and his brother have a conversation about what had just transpired. Yes. And in the course of that conversation, Erik Menendez explains about his father's assault in the bedroom. Yes. Do you remember that? And Lyle Menendez describes to Erik Menendez the confrontation that Lyle, had preceding the assault in the bedroom with Jose. Yes. And you recall Erik's testimony that he was told by Lyle that his father had said to Lyle, "Don't throw your life away." He said he would do what he wanted with Erik. He was his son. He would do what he wanted with him. He had said, "You made your choice, and Erik has made his choice, and I will make my choice." Do you remember this testimony that was some of the content of the conversation that Lyle Menendez related to him? Yes. You see how difficult it is for her to ask a gosh darn question just because of all these parameters she has on her by the judge, which we talked about at the end of the last episode, 79, when they went into like a big argument after the jury was sent home about being able to talk about PTSD in such ways and to be able to ask certain questions about PTSD. And it became a huge argument, which I don't think it needed to be. And it's like, well, it's violating this code, but in this court case it says this, and I don't know. It was just a dumb exchange back and forth. And now here we are still like she's cornered into this tiny little box where she can't ask questions anywhere around her parameters. And when she does, she gets objected to. If she tries and she tries to be too specific in her questions and the way that she words them, she gets objected to. Like everything just is difficult for the defense. If you haven't noticed by now, just everything is difficult for the defense to get their case in. Did I read that? Do you remember his testimony that that was the same content of the conversation that Lyle Menendez related to him? Yes. Do you remember his testimony that Lyle Menendez also admitted to Erik that he, Lyle, had threatened their father with revealing the molestation in order to stop it? Yes. Do you remember Erik's testimony of how he reacted to the news of that conversation? Yes. What do you remember him testifying was his reaction to the information about that conversation? That he was frightened. Do you remember his testifying that he told Lyle Menendez he couldn't believe that Lyle Menendez had threatened their father? Yes. Do you remember Erik Menendez testifying that he was so frightened by this information that he was hysterical? Yes. And, well, first of all, is the information that Erik Menendez testified that he perceived those words of his father concerning making those choices, concerning do what he wanted, concerning throws one's life away, he perceived those words of being a threat to kill him. To do anything to keep the secret from coming out? Yes. Now, in your opinion, did the fact that Erik Menendez suffered from PTSD at the time have an impact on his perception of those words as threats? Yes. How? It had an impact on his perception of those words as a threat because he had such intense anxiety as part of his post-traumatic stress disorder. He said intense anxiety. Are we sure we're not going to get an objection here? So, that base level of anxiety then I don't know why my dogs are barking. So that base level of anxiety then amplifies his perception of that information as threatening information to him based on his past. You had talked about earlier in your testimony about people with PTSD being hypervigilant. Yes, says Dr. Wilson. And are people who are hypervigilant scanning for cues? Yes. And reading things into things that they see and hear? Correct. In your opinion, was the statements that were purportedly made by Erik Menendez or by Mr. Menendez objective threats by Jose Menendez? I'm not sure I understand your question. The statements that Mr. Menendez made to Lyle Menendez concerning choices in that language, are those objective threats or are those something only someone with PTSD could read as a threat? Objection, improper expert opinion. Sustained. Did Erik Menendez in his testimony, did he indicate that he saw those as direct threats? Yes. Now, do you remember Erik Menendez's testimony that following this exchange of information, his brother Lyle demonstrated both in word and demeanor fear of being killed by their parents? Yes. And in your opinion, does the fact that Erik Menendez strike that, in your opinion, given the diagnosis of Erik Menendez as having PTSD, is there a significance to his on his perceptions and emotional state of having another person agree that the situation is dangerous? Objection vague. Sustained. Ms. Abramson says, what impact, if any, would Lyle Menendez's demonstration of his own fear have? Rephrase that question, please, says the court. What? Ms. Abramson says, first, are you of the opinion that Lyle Menendez's demonstrating fear, if indeed that occurred, had an impact on Erik Menendez that was tied to Erik Menendez's post-traumatic stress disorder? Rephrase that question also. You're asking him to assume certain facts. Sure, says Ms. Abramson. The court says, based upon the testimony of Erik Menendez describing certain perceptions of Erik Menendez. So phrase it that way. All right, says Ms. Abramson. Erik Menendez's perception that Lyle Menendez was in fear, okay, assuming that that's true, would that have any impact on Erik Menendez's state of arousal? Objection, says Mr. Khan. Abramson says, given your diagnosis of him as suffering from PTSD. Objection, Penal Code, Section 29. The court says, phrase the question along the lines of consistent or inconsistent with reaction to PTSD. All right, well, let me get the factual foundation then a little clearer, Your Honor. You recall Erik Menendez testifying that his level of fear was increased by his perception that his brother was frightened? Yes. Would the fact that another person shared this sense of fear from a threat strike that? If Erik Menendez's testimony is being confronted with his brother's fear made him more frightened, consistent with how someone with PTSD would react in a situation where they perceive a threat? Yes. Why? Because another person is manifesting anxiety in response to a perceived threat, so that anxiety in the other person now feeds, as it were, his anxiety, increasing the level of arousal. It almost like validates your reason to be feeling anxious in the situation. It validates your feelings and it makes you more nervous because you're like, oh crap, that person sees how dangerous the situation is too. You recall that following that portion of the conversation between Erik and Lyle Menendez, Erik testified that they, having both agreed that they were in grave danger from their parents, started to discuss possible options. Yes. And do you remember his testimony that the option of, for example, going to the police or going to the family or running away were determined by him to be impossible and dismissed? Yes. Now, have you described some of the symptoms that you believe Erik Menendez suffered from as part of the symptom clusters of post traumatic stress disorder, including things such as helplessness, dependence, and I don't recall what the technical word for the symptom was, but basically an inability to see consequences in a threatening situation? Do you remember that? Yes. And is the discussion of options and the dismissing of options, as Erik Menendez described it, his state of mind concerning why none of those options were viable, consistent with someone suffering from PTSD with the symptoms that you believe he had? Yes. Why is that? It was that. It is that way because evaluating that information in terms of his stress disorder, and that is to say that he's evaluating that information in terms of the perception, of the perception of his threat and his level of arousal and anxiety. And it's that level of anxiety and arousal that leads to the constriction of in his abilities to evaluate the alternatives. He also has that that learned helplessness where any of those options to him don't seem viable because he's been in a situation where he's never been able to help himself before. He's always had to continue to just take the abuse by his parents, both of them. But he didn't even realize how bad the abuse was from his mother until he realized that she was allowing all of the stuff in the house to happen to him too. She was just as complicit. What do you mean by constriction, inability to evaluate? By constriction, I mean the intellectual constriction that the anxiety embedded in the perception of threat leads him to focus on the threat much more so than to any other possible alternative because of his learning history with having been traumatized with threats and over again in the course of his life. Ms. Abramson asks, and with respect to Erik Menendez's testimonial descriptions of why he did not feel that running away was a viable option, are the expressions that he made under oath here of how he viewed that consistent with the condition of learned helplessness that you have described? Remember, I just mentioned learned helplessness. And it said his answer is yes. In what way? It's consistent with the description of learned helplessness because a person experiencing learned helplessness as part of post-traumatic stress disorder doesn't believe that they can make a difference in the outcome if they that they could consider. So any outcome or any option doesn't seem viable to them. Any outcome uh, in their favor doesn't seem in their reach. They tend to respond passively and not to see themselves as having the capacity to influence an outcome that they might consider. They don't even think that they can do something to stop their circumstances. They don't believe they can interfere and do anything. With respect, though, specifically to the notion of running away as a form of escape, asks Miss Abramson, is the explanation that Erik Menendez gave here consistent with the way in which people who have been in long-term abusive domestic relationships describe their feeling of not having any way to get away from the abuser? Objection irrelevant. Overruled, says the court finally. And the witness says yes. Ms. Abramson says, and is that true even in situations when physically the person could obviously physically leave the house? I mean, physically drive a car? Yes. So it's an emotional feeling of imprisonment rather than a physical one. Objection leading, sustained. Can you describe this feeling of not being able to escape, of what level is this being experienced typically by people in this situation? It's being experienced at two levels. First, the emotional level of feeling overwhelmed, feeling fearful and helpless, that there is no way, nothing else to do, there is no other choice, there really isn't a solution, and that's the second part of that really is the cognitive part or the intellectual part in which the person tends to have a conviction in their thinking. They have a conviction in their problem solving, which is a part of the anxiety attached to the learned helplessness, in which they don't see themselves as having viable options, even if they can physically leave. So, in that sense, it's a psychological reaction with dual components that lead to the non responsiveness as part of the learned helplessness. So, it's a psychological reaction. Let's break that down. Your behaviors and your actions, the way the reasons that you are behaving that way is because of this learned helplessness. So because you don't know how to solve your own problems, because your parents have done it all for you, because they haven't give you any autonomy of your own, all of those reasons and more, you have no ability to help yourself. They've isolated you enough, just enough from the outside world, but they still give you a little bit of what you think is maybe a little bit of freedom going and, possibly having a friend or whatever. But most of their time, we know, was spent doing tennis if they weren't in school. All right. So the non responsiveness, you mean in the form of flight? Yes. So when you like fight or flight, like when you freeze. So it's that freeze part of the fight or flight. You don't do anything. Now, do you remember the testimony that Erik Menendez gave concerning after having eliminated these other options, he and his brother decided that they should do it, that what they should do is obtain some kind of weapons so they could protect themselves if necessary? Yes. Do you interpret that information as a decision to take some kind of action? Yes. And is a decision to take some kind of action in the face of perceived threat consistent with PTSD, and particularly people who are in a hyper-aroused state, having previously perceived what they believe to be a threat? It is. So they were in a hyper-aroused state because they just received what they believed was a threat, but they already had PTSD on top of that. So all of those actions combined, they are consistent with someone with PTSD. How prevalent in your experience and based on your understanding is this area in the taking of action to ameliorate anxiety among people with PTSD? It's very common. How prevalent in your experience in this area is the taking of action to get rid of? Ameliorate means to like destroy, get rid of. So it's common for people with PTSD when they are at this hyper aroused state and when they're dealt with the threat, they may take some action. He says it's very common. Now, turning to the next day, Friday, do you remember Erik Menendez? Well, first, let's stay with Thursday for a moment. Do you remember Erik Menendez's testimony that after the discussion about obtaining a means of protection, he had very little sleep and had nightmares? Yes. We know Erik already had nightmares because Even as a child, he used to dream of a green head floating in his dreams, and that was actually his father in his dreams. He had he had nightmares all the time. I just lost my place. His answer is yes. So he did have little sleep and nightmares after this discussion with his brother. And from a PTSD analysis, assuming that that happened, what is the significance of his having the repetitive nightmares that he just testified to? Objection vague. Overruled, says the court. You can answer the question. The witness says the significance of having the nightmares, it reflects the reactivation of previous trauma. So thinking about these things over again and all these past traumas that you might have pushed out of your mind because you're so busy dealing with the other traumas that they're all reactivating in your mind. You're remembering things you forgot. In previous nightmares connected to his sexual molestation with his father, that the anxiety that he was experiencing at that time is carried forth into the sleep cycle and manifests itself as PTSD symptom in the form of a nightmare. Ms. Abramson asks, is the fact that he had one of those historical nightmares that night consistent with your diagnosis that at this time he was suffering from PTSD and PTSD was affecting his perceptions and emotions? It is. Now, do you remember Mr. Menendez's testimony that that Friday morning, the next morning, after he got up, he had a sense of the unreality of the events of the night before and was of a mind to ignore the notion that he was in a threatened situation? Yes. Based on your evaluation of Erik Menendez and the symptoms of PTSD that he demonstrated and the testing that you did of him, is that state of mind that he relayed that morning significant with respect to whether or not it was consistent with PTSD? Yes. And how or why? It's consistent with his PTSD because it's a form of defensive avoidance. It's a form of denial. It's an attempt to diminish the full weight of the threat and the intensity of the fear that he had experienced the night before. And we already know he tried to minimize the abuse when he was talking to his other doctors and all of his medical records. He tried to minimize it. This particular witness in his evaluation said, normally when people are feigning, they come right in and they're like, "Hey, I have this, that, and the other thing." Basically, like they're reading off of something they found on Google, and this is why I think I have this. Whereas someone who really suffered, someone who really was traumatized, they're not going to come right out and say it. They're not going to say, "I was traumatized. I was essayed by my uncle back when I was blah, blah years old." They're not going to just come out and say that to a complete stranger. It takes time. It takes trust building with your therapist. It's going to take several sessions, if not more, in order for that truth to start coming out before you even get to that. So we already know that when this doctor started evaluating Erik did not discuss his abuse. He basically minimized it, tried to, actually talk up his parents, make his parents seem like they were saints versus some of the monstrous things that they did. So that's another factor to it. Ms. Abramson asks, in your opinion, is that interpretation applicable to these events of Friday morning, assuming they are true? Precisely. Now, you recall Mr. Menendez testifying that he has a conversation with his brother, Lyle Menendez, in which his brother tells him that he, Lyle Menendez, believes that the threat is still real and that they are still in danger. And following that conversation, they decide to go and try to obtain weapons? Yes. Do you remember Erik Menendez testifying that that conversation indeed caused him to experience the fear again and sort of broke through that mood and that he had previously been in that maybe it never happened? Yes. Is that information that he was influenced in such a way as to re-embrace, if you will, the fear consistent with someone with PTSD and their particular vulnerability to threat? Yes, it is. In layman's language, would it be fair to say that people with PTSD are easily frightened with perceived threats or surrounding the type of trauma that they experienced in the past? Objection irrelevant in Penal Code Section 29. The court says the witness has already answered that sort of question, so ask your next one, please. All right, thank you. Now, this is ridiculous. Lawyers can usually ask something multiple times just to clarify. Like, you did say that, right? Like, you meant that. Like, what did you mean by that? They have every right to go back to previous testimony and be like, you said that, right? This is so stupid. This particular judge gets on my nerves, if you don't know that already. Ms. Abramson says, all right, thank you. Now, are you aware, or you're aware of Mr. Menendez's testimony about the activities of himself and his brother that Friday in going to a place that sold guns in Los Angeles and then driving all the way down to the San Diego area, going to two other gun selling places there? Yes. From an analysis of the relationship between Mr. Menendez's perceptions of danger and feelings about his options as he testified to them over the course of that day, and its connection, if any, to his diagnosis of PTSD, is there some portion of that day, the daytime part, that has particular significance? Yes. What is that? The portion that has particular significance is the drive to San Diego from Los Angeles, in which he is having a conversation with his brother Lyle. Why does that have a particular significance from an analysis of the interaction between PTSD and his perceptions and emotions? It's a compound question. Yes. He says several parts to it. Its relationship to the post-traumatic stress disorder is that during that drive to San Diego, Erik Menendez disclosing in greater details to his brother the particulars of his sexual molestation. He was disclosing and describing and characterizing specific events that involved not only sexual molestation but threats and violence. And in doing, excuse me, he is further revealing what happened to him, but also at the same time reliving it and intensifying his own fears and anxieties. Can't stress that enough, that you are reliving it every time he talks to a counselor through prison, every time he talks to any of his lawyers preparing for this, anytime he talks. And this is now, they were arrested in 1990. We're in 96. They've been in prison for almost 6 years now. And yeah, forgot where I was going with that. But anyways, what happened to him, but also he's reliving all those 6 years of trial, court, and going through two trials, not one but two. All of that is reliving, re-experiencing all of those fears and anxieties that he's had his whole life from his father. He has to, go into great detail in front of a room full of strangers staring at him and listening to his every word while he describes the most horrific things that ever took place in his life. But of course, Mr. Khan says, I would object at this point. This is improper expert opinion, Penal Code Section 29, and the court sustains it. The answer is stricken. I hate this judge. Ms. Abramson says, well, Your Honor, I would like to be heard. The court says, okay, again, the focus is on the expressions of Erik Menendez during his testimony of his mental state at the time relevant in this case. Ms. Abramson says, that's all the witness is talking about. The court says, not analyzing the facts. Ms. Abramson says, with respect to what you have just said about intensifying his fear, is that what he testified to? Yes. Like, why can we not say these words? It is so infuriating. Like, she can't even do her examination here, or direct examination, as she's objected to every second, like right and left. With respect to what I just said about intensifying his fear, is that what he testified to? Yes. With respect to the fact that he was that he was relating specific information about the extent of his molestation and the threats, is that what he testified to? Yes. Is that consistent with your diagnosis of PTSD? It is. That talking about the threats and talking about the molestation and sharing that information with his brother would intensify his fear. Objection, improper expert opinion, Penal Code Section 29. Ms. Abramson says, Your Honor, I would object that Penal Code 29, the court says, let me have the question read back. It does not apply, says Ms. Abramson. The court says, let me have the question read back. The record is read. What was the question? That talking about the threats and talking about the molestation and sharing that information with his brother would intensify his fear. The court says, I think the question, as phrased, is overbroad. Would or would be the appropriate phraseology. Ms. Abramson says, is that consistent with, in fact, intensifying his fears as he described if he is telling the truth? Yes. Do you see how she has to ask the question, like, if Erik testified to this, and if he's telling the truth, and if we just assume that he is not lying to us, then we can make this assumption, right? Like, you don't have to do that. It's not that hard. Like, you're putting on your defense. You should be able to just come out and say these things without all these parameters. This is ridiculous, in my opinion. Is that phenomenon that is observed in therapy with people with post-traumatic stress disorder that when they are talking about the traumas, they get very agitated and obviously fearful? Yes. So, although in the long run, talking about it makes people feel better, the act of disclosing is very emotionally upsetting. Yes, it's very distressing to the patient to reveal what's happened to them in a traumatic experience. Now, you recall the testimony that upon arrival back home on that Friday evening, Erik Menendez was told by his mother that a shark fishing trip planned for the next day was going to take place later than originally planned. Yes. Do you remember Mr. Menendez's testimony that he interpreted that information to mean that his parents are going to kill him and his brother on the shark fishing trip? Yes. Is that kind of interpretation of information that appears on the face of it kind of innocuous, typical of people with post traumatic stress disorder who are scanning for cues of threat or danger? Yes. So in reality, you change your schedule around. Everybody changes schedules, you know. A little schedule shift is nothing in the real world. You know, some people cry over it, whatever. It's not a big deal. Okay. We'll change the time. But to someone who's already suffering PTSD, already in a hyperaroused state, every little thing, they're going to internalize it. So even though the fishing trip may have been planned at a different time or they changed times, it had, I'm sure, nothing to do with the brothers. It had everything to do with Jose, and Jose wanted this trip. I'm sure he worked it out with the captain. They went at a time which was like not shark fishing time, too, which is weird. So that's another reason why it was strange that they changed the time because I think they went later because it's better for the shark fishing time, but it still was too early. So I don't even know, but I can't remember the specifics. But I know that it was a weird time for shark fishing. Anywho, I say all that to say if Jose wanted the time change, he's gonna get it. You know what I mean? He was that type of personality, and if the captain wasn't gonna acquiesce, you know, he'd find a way to get his way because that's what Jose would do. So um, something basically on the surface is not even anything to do with Eric and Lyle, but then when they're in that state of hyperarousal, like I said, it's internalized. So your mom and dad shut the door. Why did they do that? They did it for me for some reason. What's the reason? I must be bad, or they must be talking about me, or whatever. Like that's a normal reaction of PTSD. And I don't know. I hope that was a good example. Similar to you know, phrases or things that are said or done to you, you might take that as a threat, even if it's just totally innocuous. Or Jose would confront Erik all the time for things that, you know, he was upset about. So what made the night that he came in and really roughed him up that Thursday night, what made that different than any other night? Because he was already in this hyper aroused state. It seemed like a threat at the time because he was in this state of feeling like he was threatened the whole week. So it makes sense when you break it all down and look at how this Erik was feeling on the inside. So is this kind of an interpretation of information that appears on the face innocuous, and really it's them, PTSD person, scanning for cues? He says yes. Do you remember the testimony concerning the next day, that Saturday, and the behavior of Erik Menendez and his brother Lyle Menendez on the boat trip? Yes. And is that behavior, as he testified to it, staying up at the front of the boat for the better part of 6 hours in the cold and wet and not being around his father except on those occasions when the boat captain was present, is that behavior consistent with someone in a state of anxious arousal suffering from PTSD? It is. And are you aware, in fact, that beyond the testimony of Erik Menendez concerning the boat, are you aware of the testimony of the boat captain, Mr. Anderson, not to be confused with their family members, Anderson? This he's also O'Brien, I believe, Anderson, and of the woman, Ms. Gaskell, who was also on the trip. I am aware of Mr. Anderson. I don't recall the testimony of the other person, Ms. Gaskell. All right, okay. Now, you recall the testimony of, well, first of all, do you remember that Erik Menendez testified that both on the way to the boat and on the way back from the boat, his parents were completely silent? Yes. And that silence was anxiety producing? Yes. Can even silence be a cue of danger to someone who is hypervigilant? Sure. Especially, you know the look that your parents used to give you when they were mad at you, but they didn't say it. They just looked at you and gave you that stern look. But you maybe do it to your kids now. You know that look. So I'm sure that look was very anxiety inducing the whole ride back and forth, not knowing, especially not knowing, or thinking that they were going to get killed on the boat. Um, why is silence a cue of danger? Well, to someone who is hypervigilant, silence can be acute, especially if it's connected to a history where silence had significance that was trauma specific for them, meaning that there was silence in the past in connection with some kind of traumatic activity. It becomes acute. Like maybe Jose would give them the silent treatment for some time if he was mad at them. That might, be something that he would do to them, and then that would trigger even more. I don't know if that's true, but I was just giving you an example. She says, or he says, it becomes a signal, as it were, saying that something might happen when silence is present. So maybe I'm just ballparking here. Maybe when he was unhappy with Erik or Lyle's performance at tennis, at a tournament or a match or whatever, and maybe he would be silent the whole ride home because they were going to get an earful from him later. I don't know that to be true, and for all intents and purposes, I could be wrong. But maybe there was, the silent treatment some of the time there, so that could also be fear-inducing. Is there information based on Mr. Menendez's testimony that silence was historically connected to trauma? Oh, here we go. I'm just talking out of my ass. I didn't even know this. And what was that information? The information was that in Mr. Erik Menendez's experience with his father, that silence represented strength, and also silence was connected with specific traumatic sexual molestation, specifically what he referred to as rough sex. That had to do with his testimony that during those acts his father wouldn't say anything. So this is labeled as a question, but this is or an answer, but this was actually the question. Um, so this is the answer from the witness. Let's reread that again because it looks like the witness. So keep this in mind. Let's back up. Ms. Abramson asks, what was that information? The information that was in Erik Menendez's experience with his father, that silence represented strength, and also silence was connected with specific traumatic sexual molestation, specifically what he referred to as rough sex. The answer from Dr. Wilson is that has to do with his testimony that during those acts, his father wouldn't say anything, and Erik Menendez would be looking to his father's facial expressions to read his mood. That's correct. Now, do you remember the testimony that after returning from the boat that Saturday night, Mr. Menendez said that having not been killed on the boat, his level of extreme fear did diminish somewhat? Yes. And that he and his brother went off to be by themselves so that they could discuss what to do and to try to diffuse what they felt was a threatening crisis in the family? Yes. And do you remember in his testimony that what they came up with was that they would separate the next day and Lyle Menendez would remain at home to see if the parents said anything that would communicate a lessening of the danger? Yes. Now, this focus on watching the parents and listening for any words that might lean or that might mean a lessening of danger, is that consistent with notions of hypervigilance? So you're also looking for signs that, oh, okay, maybe the coast is clear and I can come out of my room now and I'm not going to get yelled at or my head snapped off when I do something wrong. My light is fading. Hold on. It's not plugged in. That's better. All right, let us continue. So now this focus on watching the parents and listening for any words that might mean a lessening of danger, is that consistent with the notions of hypervigilance? It is. I don't know if I finished my thought. So you're looking not just for cues in your environment that that there's danger or that you might be in trouble, but you're also looking for those cues that like your parents less stressed or less mad at you or whatever, and you become, your tension can ease in those situations. So that's why you're hyper vigilant to see what mood you need to be in. What kind of are you in your fight or flight, or can you relax a little bit? In fact, our words very often cues the types of cues that hypervigilant people focus on in order to assess whether or not there is a level of danger. Sure. Now, you recall the testimony that after returning to the house from, I believe, UCLA, where he and his brother had spoken, Erik Menendez said they had to ring the doorbell because the door had been locked behind them, and his mother answered the door? Yes. Do you remember his testimony that his mother was angry, and when and there was some kind of argument between his mother and Lyle Menendez over not having a key. And when Erik Menendez tried to say something in that conversation, his mother turned on him and said that if he had kept his mouth shut, the family might have worked out. Do you remember that testimony? Yes, yes, I do. Do you remember that he testified that he found that statement of his mother's to have enormous significance? Yes. That he interpreted that to mean that the family was over, had not worked out. Yes. And that he interpreted further to mean that his parents had formulated a plan to get rid of himself and his brother? Yes. And in that perception in his part that his mother was part of a plan to get rid of him, based on that statement, consistent with the way that someone with post traumatic stress disorder who has been in a hyper aroused state for at least 2 days by that point tends to read a great deal into verbal cues? It is. And assuming that the information we have discussed so far is accurate, is it also consistent with strike that? Assuming that the information that we have been talking about so far is accurate, is the way Erik Menendez testified he reacted to that information from his mother Saturday night consistent with the manner in which he expressed his reaction to learning that she knew about his molestation? It is. Does it make sense from PTSD and hyperaroused state analysis that having discovered that his mother was indifferent to his victimization and having translated that into the fact that she would be willing to see him dead, that he now concludes that she would be an active participant in his death? Objection vague. Sustained. Is there a psychological link between, assuming the information as he reported it, between his reported conviction by Saturday night that his mother was part of a plan to kill him and the conversation that he had with her on Thursday night? Objection irrelevant. The court says sustained as to the form of the question. Ms. Abramson asks, when people are who are suffering from PTSD are in this hyper-aroused state and they're scanning for cues, do they have a tendency to pile fears upon fears? Sure. Do they have a tendency to interpret any ambiguous information as further proof of threat and fear? They can. I would object to this and asked I would object to this as asked and answered. The court says overruled. Your answer was? The witness says they can, yeah. Ms. Abramson says, and in your opinion, Dr. Wilson, was Erik Menendez's reported state of mind on Saturday night that this conversation with his mother led him to believe that a decision was made in which she was a participant to kill him, a product of his suffering from PTSD? In my opinion, yes. And was it a product of the events that preceded it on Thursday and Friday? Yes. And would someone in that state at that point, given the course of events over those preceding days, have available to them the rational faculty to say, "Wait a minute, this doesn't make sense"? I'm not sure I understand your question, says the witness. You know the expression reality check? Sure. Okay. Are people in this hyper aroused state prone to do reality checks? No. Why not? They're prone not to do reality checks because of the intensity of their anxiety. They are so aroused, they are flooded with such intense emotion that may be flooded with such intense emotion, which may be anxiety or it may be other emotions connected to PTSD that is trauma specific based on previous trauma experiences. They can have many different types of many different negative emotions come back. Anxiety could be one of them, but there could be others, such as fear and horror and terror and apprehension and dread. So, those kinds of emotions are so powerful that they tend to overwhelm the person's capacity to evaluate exactly what's taking place in the context of any situation. Is there a concept called focusing on the fear that is prevalent among people with post traumatic stress disorder? Not sure what you're asking me. Locking into the fear, basically. When they are in a state of arousal and they're experiencing fear, they become obsessed with it. Mm-hmm. And is the description that Erik Menendez gave about his thought processes from that Thursday night through Sunday consistent with someone who has locked into the fear that to the exclusion of all other thoughts? So you are hyper focused on that fear. He says it is. Now, you recall the testimony of Erik Menendez that after having this exchange with his mother, where she tells him the family hasn't worked out, that he goes up to his bedroom and he fears his father approach and his father bangs on the door. Yes. And do you remember his testimony that he had the shotgun in his hand with 2 rounds of birdshot in it and felt unable to use the weapon? Yes. Is that a description of him as his sense of powerlessness in spite of the fact that he's holding a shotgun in his hand, consistent with post traumatic stress disorder? Yes, he had a weapon to protect himself and still felt helpless. Is it consistent with something I think you described earlier, the tendency to freeze? Yes. What causes that tendency to freeze? The tendency to freeze, when it's associated with PTSD, is a fear response. It's a shutting down of responsiveness. And so, freezing, as we use that word, means a stoppage of activity, a cessation in response out of a heightened sense of arousal. The freeze component has underneath it, as it were, this intense level of extreme arousal that leads then to the freezing response or a lack of movement or reactiveness in the situation. Is the freezing response, strike that, is the freezing response connected or frequently connected to people who took passive or were passive victims in the trauma? Yes. Is there descriptions by Erik Menendez in his testimony concerning the sexual molestation that signified that he rarely resisted and was basically passive with respect to his father's assaults? Yes. Is freezing, we'll strike that. Do you remember Erik Menendez's testimony that one of his concerns, just to go ahead for a moment on Sunday, in the face of what he perceived to be an immediate threat of death from his parents, was that he would freeze and not be able to do anything to defend himself? Yes. Is that concern on his part the belief that he might freeze consistent with PTSD? It is. Now, turning to the events of Sunday, you recall Mr. Menendez's testimony from the day about that day? Yes. And have you reviewed it rather carefully? Yes. You recall his testimony that he stayed away from the home all day, expecting his brother to read the signs at home as to what the level of danger was? Yes. This discussion that Erik Menendez testified he had with his brother about listening to what the parents say and seeing what they do, is that consistent with two people talking about being hypervigilant? It is. And you recall his testimony that when he arrived home at the end of the day, Lyle Menendez told him about two actions on the part of the father that Lyle Menendez, interpreted as being dangerous? Yes. And you recall Erik Menendez testifying that he too thought those two pieces of information indicated that the parents were planning to do something to them? Yes. Do you remember those two pieces of information had to do with Mr. Menendez telling Lyle that an activity that he had wanted Lyle to participate in no longer mattered? Yes. And the other piece of information was that Lyle told Erik that their father had lied to Perry Berman, apparently in an effort to keep Lyle and Erik from making any plans to be with anyone that night. Yes. So it could make you think, well, mom and dad want me home tonight. Why is that? Maybe they're planning on doing something. Do you remember that Erik Menendez testified that Lyle appeared to be very anxious and frightened as he relayed that information about these two significant events? Yes. Do you remember Erik Menendez's testimony that that his fear elevated dramatically when he heard that information from his brother and saw his brother's fearfulness? Yes. Do you remember his testimony at that point that he and his brother decided to leave to get out of the house? Yes. And is that decision, given the context and assuming, of course, as always, that this information is accurate, that decision to leave, is that an example of attempted flight behavior? It is. Do you remember the testimony that Erik and Lyle Menendez, went to the house in order to tell their parents that they were leaving so as to not to do anything that would arouse wrathful action on the part of their parents at that time? Yes. Now, Dr. Wilson, you are aware of the facts as testified to by Erik Menendez concerning the specifics of the confrontation that occurred at the house when he and his brother went to tell the parents that they were leaving? Yes. You recall Erik Menendez testifying to how he was reacting emotionally throughout the course of that confrontation, to which he was mainly an observer? Yes. Do you remember his testimony that he was thinking that he could not believe that his brother was actually engaging in an argument with his parents at that point in history? Because they never argue, like they never fought back. I do. Is that thought on his part, first of all, do you remember him indicating that he felt that was extremely dangerous for his brother to engage in this argument? Yes. And from reviewing his testimony, did he indicate placing enormous significance on certain words that were spoken, certain expressions that he saw on his parents' faces that were being read as cues? Objection, argumentative as phrased. Rephrase the question, says the court. Let me ask you this, says Miss Abramson. Do you examine the information that he testified to about those few minutes before the shooting with great care? Yes. Did you form the opinion that Erik Menendez's perceptions of what was going on and his reactions to what was going on were related to his post-traumatic stress? Yes. And could you tell us specifically what information from his testimony concerning his perceptions and his reactions were, in your opinion, the product of PTSD? Objection, improper opinion. Overruled, says the court. The witness says, could you rephrase the question again? Abramson says, okay. What specific facts, as he testified to them from the last few minutes before the shooting, the court says, acts or statements of his state of mind? I was about to do that, Your Honor. Facts, what's going on, his description of what he's perceiving, what his state of mind was, what his reactions were of significance. Yes. Okay, which facts, which perceptions are of significance? The witness says there are several. The two key ones for me is where Mr. Erik Menendez was told by his father to go upstairs and that he would be there in a minute. That's number one. That's to me very important in terms of his PTSD because in the past, when he was told to go upstairs by his father, who said he would be there in a minute, that indicated to Eric that an episode of sexual molestation was about to take place. So that's important in terms of his perception that there is the threat that the father will come upstairs to his bedroom and that he might have to engage again in an act of sexual molestation, which created a great deal of anxiety for him in terms of his PTSD. The second piece of information that's particularly important to me is where Mr. Erik Menendez heard his brother say, as his brother came upstairs to the room, "Can't you see it's happening now?" And the relevance of that in terms of Mr. Erik Menendez's PTSD is that it led to an incredible panic state. Mr. Khan says objection, improper. I'll withdraw the objection. Okay. Ms. Abramson says, he described an incredible panic state, did he not? He did, yes. And is an incredible panic state in the face of this, number one, a cue to prior trauma, and number two, someone else confirming that the fear of being killed that he had in his mind for several days is being realized. Okay. Are those the kinds of things that are consistent with someone with PTSD going into the highest level of hyperarousal? It is. And Erik Menendez testified, did he not, that it was at that point, we'll strike that. He testified, did he not, that after hearing his father say, "Go to your room, I'll be there in a minute," he experienced a return of fear and panic over the notion that he would have to deal with his father in his room again. Yes. And he also testified, however, that when his brother said, "It's happening now," I think he described it as a freak out, total panic state. He went brain dead. Wasn't thinking, was all of those words? Yes. And is that state of mind consistent with someone who has gone from hyperarousal to survival mode action? Yes. So you're going from hyperarousal to "I'm going to die any second" type of mood. In the manner in which Erik Menendez described his thought processes, or actually lack thereof, over the course of the next few minutes, consistent with what's understood to be the neurobiological operation of extreme fear. Yes, says the witness. In what way? Simply stated, he went from stimulus to response. He went from a perception of the threat into a very intense, hyper-aroused panic state, leading to an immediate reaction without intervening thought and reflection. Okay, you recall his testimony that the only thing that was going through his head was the word hurry, hurry, hurry? Yes. And the only thought he remembers really having was, "I've got to get to that room before they come out and get me." Yes. Now, is that kind of thought reflective thought? No, it's not. And with respect to his perception, particularly after his brother said, "It's happening now," his perception that the threat was upon him, that he was about to die? Yes. Is that sense of imminency consistent with the way that people with PTSD evaluate the onset of the threatened event? Objection. I believe this has been asked and answered in another form. Court says overruled. The witness says, yes, it is. Um, can you explain that? Yes, it's consistent with someone having PTSD to evaluate it in that way because in the past they've had these threats and the threat has been carried out. They have had these experiences which are traumatic and overwhelming to them. So when the situation occurs and it appears that it's about to happen again, the person's emotional response is that it's, "Oh my God, it's going to happen again. It's going to happen right now," because based upon their prior traumatic learning, that's what they've experienced. That's what's happened to them. So the emotional reaction is automatic. The sense of having that intensity reappear as part of the post-traumatic stress disorder. It's almost like your body knows. It reacts to the situation because it's been in that situation so many times. So it just reacts. It goes into this hyper arousal state and into survival state mode. You know what I'm saying? So it just activates. It's like it's there and it activates and turns on. Is there a distinction in your mind, Dr. Wilson, between someone who feels threatened and is uncertain about when the threat is going to be realized versus the tendency of people with PTSD to always emotionally react as if a threat is going to be realized right then? Well, there is a difference if that's what you're asking. Okay, and is the difference the sense that the threat's going to happen right then a typical symptom of how people with PTSD react to the perception of threat? Yes, it's the symptom of acting of or feeling as if the traumatic event was reoccurring because they have an association with a thought or stimulus that reminds them of what they've gone through before. You recall you testified earlier about some of the research in the neurobiology of post-traumatic stress disorder? Yes. And one of the focuses of that research was to determine why biologically and chemically people with PTSD go from stimulus immediately to survival mode without intervening cortical reaction. Yes. Is it commonly reported phenomenon of people with that would be people with post-traumatic stress disorder that the minute they perceive a threat, they believe it's being carried out right then and there, that they believe it's imminent. Got the word in imminent and they didn't even object. He says, for many, that's correct. And is Erik Menendez's testimony in this case that he perceived that the threat was imminent consistent with the manner in which people with PTSD, having read what they believe are cues of impending harm, accelerate that harm to a sense of imminence? Yes. Now, you recall the testimony of Erik Menendez that after his brother says it's happening now, he is in this panic condition. He gets this gun and runs out front and loads it up, all the time thinking, hurry, 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 go get there before the doors open. Yes. Do you remember specifically his testimony of racing towards the room and opening the doors and then seeing something? Yes. Now, in your evaluation of the connection between post-traumatic stress disorder and what happened, we'll strike that, and Mr. Menendez's mental state that night, a Sunday night, did you note that he described what he saw inside that room as the first person that he saw, he described as a shadowy figure? Yes. And did his choice of words, the description that this was a shadowy figure, have significance in your opinion in support of your conclusion that his perceptions that night were a product of PTSD? Yes. Why is that? I'm not sure what the latter part is you're asking. Well, what significance from a post traumatic stress disorder analysis did his use of the word or his perception that night that he was seeing a shadowy figure have? The significance, says the witness, as it relates to the perception of a threat, that there is this image that he perceived upon entering the room. That's perceived by him to be a threatening figure that was coming towards him. Abramson says, okay, maybe I'm confused. Did the shadowy figure relate back to anything in his trauma history? It does. And did the fact that it related back to something in his trauma history, excuse me, I am being paged. Committee decision here. The court says, let's just ask another question, please. Ms. Abramson says, thank you, Your Honor. Did Erik Menendez describe the fact that, do you remember him describing the fact that much of the molestation occurred at night in his room? Yes. And that his father would come into that room in the dark on occasion, correct? And would represent as a shadowy figure? Yes. Now, assuming just for the purpose of this question that when Erik Menendez opened the door to the den, he was already in an extreme panic state, as you described, okay? Okay. Would the appearance there of a shadowy figure something that relates back to the trauma only further confirm his terror? Yes. And are you familiar with his testimony that he did not start firing until after he saw that shadowy figure? Yes. Your Honor, this would be a good time to break if we're going to break this morning. The court says, we will break, let's go on a little, or we will break, but let's go on a little further here. She says, all right. That's so annoying when the attorney who's asking the questions is probably like, this is a good time because we might get into a longer conversation here, or I just know that, this is a good breaking point. And the court's like, nah, keep going. So, like, belittling. And it kind of throws you off your game, too. Ms. Abramson says, all right, so now you recall his testimony that he rapidly fired all rounds of the gun. Yes. Is there anything about that that's inconsistent with someone in a panic who has PTSD? No. Do you recall his testimony that all he recalls seeing is the flash of fire coming out of the gun? Yes. Is there anything inconsistent about that testimony with the notion that we're talking about a person who suffers from PTSD who is in a panic state? No. Do people in a panic state tend to have constricted vision and sort of what we call tunnel vision, where they don't really see a lot of detail? The witness answers, often there is perceptual distortions, correct. So your memory can do funky things when you're in a traumatized state. You had described, I think at one point, a phenomenon such as bank clerk who would be the victim of an armed robbery where a gun was presented, and the gun assumes enormous proportions and blocks out all other information, basically. Yes, visual information. That's correct. And that's typical post-traumatic stress disorder reaction to a threat? Yes. So is the description that Erik Menendez gave of not seeing any real specifics inside the room except the flash of the gun consistent with someone operating in that high state of panic where vision is constricted? It is. Now, you recall the testimony that Mr. Menendez gave concerning his state of mind immediately following the shootings? Yes. That he was in a state that was basically numb? Yes. Have there been studies of people with PTSD who take survival action in what their mental processes are during the taking of that action and immediately thereafter? Mm-hmm. Is there anything inconsistent in the way that Erik described his state of mind after the shootings with your diagnosis of post-traumatic stress disorder? No. Now you're aware, are you not, Dr. Wilson, of Mr. Menendez's testimony, in fact, of all of his testimony in this trial? Yes. You haven't memorized it, though. It's a lot to memorize, no. I know. All right. You're aware of his description of what the events were after the shooting where he and his brother left. First of all, picked up the shell casings, correct? I think there was activity prior to that, actually. But we're talking about after the shooting. There is a period of time when they're in the foyer and they have a discussion about whether the police are coming and why aren't they coming, and then they decide maybe we can leave. Yes. And then on the way out, Erik Menendez testified it occurred to him that there were shell casings. It occurred to him if they were leaving, maybe they shouldn't leave fingerprints. Yes. And so they went and turned on the lights and picked up the shell casings? Yes. And then they left the house and got in a car and started to go in one direction and then turned and went in another direction, having decided to go to a movie theater and see if they could get some tickets. Yes. And they failed to get tickets, and then they went and disposed of the guns. Yes. And then they went and failed to meet someone that they had said that they would meet. Yes. And then they called that someone, or at least Lyle Menendez called that someone Mr. Berman, and there was another plan to try to meet Mr. Berman at a restaurant. The Cheesecake Factory, yes. And do you remember Erik Menendez's testimony that he was emotionally unable to go meet Mr. Berman at the restaurant, that he was, I think he described it as falling apart? Yes. Now, is that reaction, that's sometime within, say, about an hour after the shooting, Erik Menendez described himself as falling apart, is that in any way inconsistent with someone with post-traumatic stress disorder who has reacted to a threat in an extreme way? No, it's not. Is it consistent with that? Is there any specifics about that that's consistent with the known behavior of other persons suffering from PTSD? Yes. And in what way? It's consistent with persons suffering from PTSD that in the immediate wake of the traumatic experience or a threatening experience, they think, after experiencing panic, may go into a state of exhaustion where they're depleted and ordinarily fatigued and tired, as well as still anxious, and a feeling that they're completely overloaded at that point in time by what's just happened. Now, you recall that Mr. Menendez testified that he and his brother, after calling Mr. Berman and saying that they were going to stop at the house first, that then he and his brother returned home. He went in the den and at that point realized that there were no weapons in the den. Yes. And is given what he explained was his mental state at the time of the shooting, this extreme panic without thinking, is it consistent with his suffering from PTSD and these extreme emotional states being a product of it that only this much time later would some with some reasoning start to happen again in your head, some look at the objective surroundings to reality check what he thought was going on before? Yes. So it's consistent with someone who is in this extreme state of panic, not paying attention to their surroundings, or at least not remembering them after the fact, and you're hyper focused on whatever that one thing is. Versus now you're starting to clear your head. Now you're starting to realize the severity of the situation, and you realize that you just killed them, and there were no guns in the room. So they did not have guns in there plotting to kill you, even though that's what they thought. Although we can argue that just because they didn't have guns in the room doesn't mean that they weren't plotting to kill the brothers or to do something with the brothers. Now, you're aware, are you not, Dr. Wilson, that based on testimony of a number of witnesses, including the 911 operator from the Beverly Hills Police Department, that Lyle Menendez called the police after they returned home? Yes. And that Erik Menendez testified that he was genuinely hysterical after being confronted with what he had done and realizing that he had been mistaken in his apprehension uh, of imminent death. Yes. And you're aware of the testimony that he became quite hysterical after that and was quite hysterical when the police were there at his house? Yes. And you're aware of the testimony that he eventually went to the police station and had a conversation with Sergeant Edmonds? That's correct. The dog's got to go out. Hold on. All right. Next question. And you're aware of Sergeant Edmonds' testimony that he, Erik Menendez, became very tearful, was sobbing, and the interview had to conclude? Yes. He was tearful at the end of the interview, as I recall. Is that emotional reaction of Erik starting from the point when he testifies that he lost control emotionally on the way back from the Santa Monica Civic through the entire through the interview, sorry, with Sergeant Edmonds, consistent with someone who has acted out of a sense of panic without carefully reasoned thought, comes to regret it? Objection, improper expert opinion. Sustained. Is there anything in that reported behavior, reported by both Erik Menendez and others who observed him, that is inconsistent with his having acted as a consequence of post traumatic stress disorder in a state of extreme panic and survival mode at the time of the shooting? No. I'm going to change subjects, Your Honor. So if this is a good time, the court says, all right, we'll take our recess and we'll resume at 5 minutes to the hour, 20-minute recess. We'll resume at 5 minutes to. Don't discuss the matter and don't form any final opinions about it. A recess was taken. We come back. The court says, all right, we're ready to resume. Ms. Abramson says, just give me a moment, Your Honor. I just want to review my notes and see where I'm going. We should finish pretty quickly. There was a brief pause. And then she says, "Oh, Your Honor, I know what. I wanted to introduce a photograph. People objected and we put it off. I would present this photograph I'd like to admit is one that was taken from the notebooks of photographs that were shown to the prosecution that they had in their possession for some period of time. A little photograph showing with a date on the back of 1976. It is apparently the Monsey house. Based on the decor and other photographs we have of the location, it shows three people in Halloween costumes. And the witness can identify one of them as Erik Menendez, based on the birthmark on his arm, which shows, and one of the others is wearing a green fright mask as described by Erik Menendez in the episode with his parents putting a mask in his closet, and also as described as recurring images in his nightmares. The court says, "What is your offer as to why this would be relevant evidence to the witness's testimony?" Ms. Abramson says, "Because this witness interprets, well, first of all, the witness saw those photographs and thought they were significant because of the presence of the green fright mask. It is close in time to my client's recollection of when his molestation began at the hands of his father, and in interpreting that dream having to do with the green face, it's the dream in which the green face is connected to the molestation trauma. And following that, my client took isn't he her client? My client took these photographs to the county jail and showed them to my client. So, okay, so I don't know who that was. Maybe her assistant or somebody took them and can testify to my client's reaction as observed by the witness. What is being offered for? Ms. Abramson says it's being offered to corroborate my client's testimony about the green mask and that was in the closet, to corroborate his testimony about having nightmares in which this green mask is featured and becomes his father in the dream. It's offered as external corroboration of that testimony. The court says it's also offered for the truth of the matter asserted. Ms. Abramson says it's offered to show that there was a green mask that he saw. The court says this witness, Ms. Abramson says, he's in the picture. The court says this witness was not an eyewitness to the event at issue. He doesn't know anything more about it other than what your client told him. Ms. Abramson says, well, he can see it in the photograph that that my client is in the room with this green mask. The court says if your client wanted to testify about it and let the jury hear his testimony if it has some relevance and was admissible, it would have been dealt with, during his testimony and not this witness. Ms. Abramson says, well, I'd like to bring out from this testimony, from this witness, my client's reaction. I'll recall my client to testify to the green mask if I have to. So she will recall Erik if she needs to. The court says his reaction wouldn't be relevant. Ms. Abramson says, I think it would from an emotional standpoint of whether this had emotional impact on him. The court says, I'm not going to get into that. None of this testimony of this witness about what your client said is offered or received for the truth. If there is a limited instruction, which I assume the people will request. Ms. Abramson says it supports this witness's conclusion that my client had post-traumatic stress based on the sexual molestation because of the symbolism of the mask. The court says we've already had testimony about what matters. The offer of proof that you're making doesn't support the position that the evidence is admissible through this witness. Therefore, the previously stated objection by the prosecution is sustained. Anything else before we have the jury come out? No, says Ms. Abramson. So they wanted to bring in this picture that I think they had every right to bring in, which is this green, it's a kids of and somebody's wearing this green mask, or at least this green mask is in the photo, which symbolizes to Erik the molestation, the monster that Jose could be when he was behind closed doors. But the court won't let it come in. Ms. Abramson says she doesn't have anything else. The court says, okay. Ms. Abramson says, let me think for 1 minute. There was something else that was objected to yesterday because I'm going to wrap up this morning. Let me just state that I'm going to use the blow up of the transcript of the 1211 tape, the Oziel tape, in the next segment. If the people are going to object, I'd like them to do it now so we don't have to interrupt the testimony. Hearing no objection, the court says, "Have you seen that, Mr. Khan?" "I don't know what counsel is referring to," he says. Miss Abramson says, "It's one of the charts that's sitting back there." Mr. Khan says, "Perhaps, if counsel," Miss Abramson says, "How could you not know what I was referring to? I marked it yesterday." Mr. Khan says, "Perhaps counsel can identify the chart." Miss Abramson says, "It's 402. The court says, "If someone wants to get it and we can see it." Mr. Khan says, "We filed with this court a motion some time ago in which we sought to exclude testimony from expert witnesses concerning the December 11th tape, and I believe that is one of those matters." So they did file a motion to exclude testimony for expert witnesses, and they don't want them talking about the Oziel tape for some reason. And I believe that that is one of those matters that is put on the back burner at the request of counsel because counsel gave assurances to this court and to the prosecution that it was not necessary to get into these matters. I don't think it's appropriate for counsel to now just spring this on us in her last minutes of direct examination of this witness. We were going to have to revisit this matter to determine whether or not testimony from the witnesses is admissible, and it might be subject to a hearing depending upon exactly what she is going to ask and elicit from the witness. I think that should be done when we have appropriate time to devote some attention to it. So I would ask that counsel conclude her testimony, her direct examination of this witness, and make an offer of proof after we're into the cross examination as to the precise areas that she seeks to question this witness to determine whether or not we need to have an extensive hearing outside the presence of the jury. Ms. Abramson says, "Well, counsel is misrepresenting the status of their objections." First of all, I didn't say we weren't going to go into this, and I didn't ask it to be put on the back burner. It's just a matter that got put over along with other matters. It behooved the people that were still pursuing their objection to make it before this witness took the witness stand when we were doing 402 issues. Number one. Number two, the tape is at the center, if you will, of the prosecution case. They are relying on it heavily. The witness obviously has an opinion different than that of the people's interpretation and what the tape is. And I think that it's mandatory that I confront the witness with this information, that he is familiar with him, and ask him, obviously, why the information contained in this tape does not change his conclusion as to the relationship that this is a homicide connected to my client's PTSD. And I think the witness has a right to explain why, in the face of the evidence, he maintains his opinion. So he has every right to say, "I reviewed the Oziel tape, and here's my opinion of it." I don't know why this is being objected to, but whatever. The state doesn't want expert witnesses to talk specifically about the Oziel tape, even though they're using the Oziel tape as part of evidence as to like motive and all sorts of things. But yet the defense can't use it for some reason. I lost where I was. That the homicide connected to my client's PTSD, blah, blah, blah. Okay. And I think the witness has a right to explain why, in the face of evidence, he maintains his opinions. The court says, what is his answer going to be? Well, I think his answer is going to have to do with a number of features of this case. The court says perhaps his opinions might not be admissible evidence. Just because he has opinions doesn't necessarily mean that they become admissible. Ms. Abramson says, I think that an expert witness's evaluation of a piece of evidence that appears to be contrary to his opinion, that expert has a right to explain why it is contrary, why it is not persuasive to him with respect to his opinion. I don't imagine for one moment that the people were not going to cross-examine him about this tape. And if they are going to cross-examine about it, then we should be permitted to have the witness explain why what appears to be inconsistent evidence does not, in his view, change his opinion. The court says, what is he going to say? Well, I think he's going to say, says Ms. Abramson, that the way that the information is relayed on the tape, Dr. Oziel is positing a hypothesis with which my client basically does not agree. That in the early stages of the tape, it is Dr. Oziel who's coming out with conclusions and interpretations that are not the words of my client and with which my client does not agree. I think to counteract what I believe is going to be the prosecution's theory that this is a therapy session, and therefore it has made validity it has more validity as being truthful. I think Dr. Wilson should be entitled to show how Dr. Oziel fails to follow up on information that is consistent with the information that Dr. Wilson has. I think he has a right to highlight where, in the course of that interview, my client starts to say things that are interpretable as being truthful things, how Dr. Oziel cuts him off, doesn't follow up on those things, doesn't explore them. I think we should have a right just a moment. Let me get my notes out of the outline on this. Just a second, Your Honor. I just want to cover all the. Okay. I think he's going to say that when he forms an opinion, he bases it on materials that have some consistency or have some logic with respect to his expertise and the theories that are revealed in this tape about a mercy killing on the one hand and a killing because of harm done to the person who was a mercy killing is not psychologically, I don't want to say logical. Logical is not the word, but it doesn't make psychological sense. And he's going to point to aspects in that the taped statement that are consistent with his opinions, such as Erik Menendez professing love for his parents, talks about his remorse, talks about the fact that he keeps couching in his involvement in the killings as a situation where he had no choice. So he is going to talk about what aspects of that tape are consistent with his view and why it's supposedly inconsistent parts are not persuasive because of the way in which the conversation is conducted. Okay, says the court. What's the people's response? Mr. Khan says, well, Ms. Abramson premised her offer of proof upon her anticipation that I'm going to be cross-examining this witness with regard to the December 11th tape, and that's not correct. I don't intend to ask the witness any questions whatsoever concerning the December 11th tape, so if that's her offer of proof, I ask to be denied on that basis alone. Moreover, I think counsel should not be able to use a witness to explain away incriminating evidence, and that's what she seeks to do with this witness. She is abusing expert testimony by having them not only give a basis for their opinion, but also she tries to argue away incriminating evidence. The fact of the matter is this witness fully testified to the basis for his opinion and fully explored that issue. Counsel fully explored that issue before the jury as to over everything he took into consideration in formulating his opinion. This December 11th tape is not a basis for his opinion in this case, and I don't think counsel should be permitted to use the piece of evidence which is incriminating to try to argue the people's case. And that's precisely what he's going to do. It's not the proper subject of expert testimony, and it's not necessary part of the expert's opinion. Okay. I think it makes sense when there is contrary evidence that he had at his fingertips. It was available to him to review. Why can't he get into it? It makes no sense. Especially because he's a psychologist and he knows about PTSD and he's the same field that Dr. Oziel is. So why can't he also evaluate that? Makes no sense. Ms. Abramson says, I don't think I'm limited in explaining a piece of evidence, which is virtually the first piece of evidence the jury in this case heard and is hanging out there. I think if I'm putting on an expert whose opinion is obviously contrary to the import of that evidence, that he should have a right to explain how he dealt with that piece of evidence. Otherwise, it's going to look like he didn't consider all the evidence. Something has been either withheld from him or he's ignoring something without considering it, and it undermined his opinion. To not allow him to talk about why this piece of evidence, which on the face of it appears contrary to his opinion, is not persuasive to him. The court says, Well, the problem with that is that there's other evidence in this case, Ms. Abramson says, which we're also going to do. The court says we've had a lot of witnesses who testify on different subjects. Basically, what you propose is to give the witness free rein over the entire trial, to comment as he chooses on whatever evidence has been presented and give his interpretation of it. Are you freaking kidding me? Like, I'm getting mad reading this. She says, that's not true, Your Honor. The court says that's what you're saying. Ms. Amerson says, this is a statement by my client, which the people have made a big deal out of and no doubt will make a big deal out of in the final argument. The court says there's no dispute about that. What right does the witness then have, or what right does the defense have to have an expert witness to come in and start commenting about it? The right to a fair trial? Why can't they? That makes no sense. Ms. Abramson is like, he has a right to defend his position in the face of what appears to be contrary evidence, particularly when he has testified he based much of his conclusions on information he has received from my client, for which no doubt his opinion will be attacked because he's basing it on the words of my client that he likes, and the argument will be the words he doesn't like, he ignores. So I think he has a right. This isn't going to take a great deal of time. Court says, first of all, the witness has no right at all if you want to phrase it correctly. The defense has a right to bolster the credibility of their one and only permitted expert witness when all other corroborating witnesses to much of what he has testified to have been precluded. We are down to the point when the whole credibility of this defense is riding on my client and his witness because of the way in which the defense has been limited by the use of 350 and 352. Therefore, I think that in order to constitute putting on a defense as that is understood, we at least are entitled to support the credibility of the two witnesses that we have been allowed to call, and particularly when it's an expert witness with whom juries often have credibility problems. As we all know, I should be permitted to ask him why this piece of evidence doesn't dissuade him. He cannot simply ignore the prosecution evidence. I intend to ask him if he's familiar with the evidence of spending and whether that evidence dissuaded him or changed his mind. I intend to ask him about the evidence of the statements that my client gave to the police and the fact that he was obviously not truthful with the police and why they didn't dissuade him. I can't just ignore bad evidence and make the jury think I've put a witness up here who's a Pollyanna and who's been kept in the dark. I think that's inappropriate. She's absolutely right. She should win this. But it doesn't seem like the court is persuaded to rule in her favor so far. We'll see. She goes on to argue, I think I need to be able to bolster his credibility or at least show he's a thorough scientist, that he considered everything. And I am to interpret the people's remarks as understanding that Dr. Dietz is not going to be giving the 1211 tape, that Dr. Dietz is not going to be considering. The court says, let's just focus on what we're dealing with on this witness. You can't start rebutting witnesses who haven't testified, who might not testify. Let's just talk about what is before the court right now. Ms. Abramson says, what is before the court right now is, I believe it is mandatory that I present the witness with the prosecution evidence so that the jury at least understands that he considered it and is aware of it, and allow him to offer some explanation as to why what appears to be inconsistent evidence was not persuasive to him. Now, whether it's persuasive to the jury is a different issue. It's only a matter of whether it's persuasive to him. The court says the people wish to be heard on that. Mr. Khan says, yes, I think that what counsel is permitted to do, according to the evidence code, is to have the witness testify to his opinion and the basis for his opinion, and this witness has fully done that before this jury. The evidence code does not provide counsel with the opportunities to use a witness as a sounding board to run by the jury her entire theory of the case, and that's exactly what she wants to do. No, she doesn't. She's doing what every good lawyer should be doing with their client, is to refute the bad evidence against them. What kind of argument is this? He goes on to ask, should we ask the witness, did you believe Jamie Pisarcik? No. Why? I didn't find Jamie Pisarcik to be particularly believable. How about Perry Berman? Weren't you persuaded by Perry Berman and what he testified to in this courtroom? No, I think Perry Berman is mistaken about a couple of things. This guy is going off. He's in a different mental state than the rest of reality. Um, and then he continues with, how about Clara Wright and her husband, Mr. Wright? Didn't you find their testimony to be persuasive? No, I think Clara Wright may have had a lapse in memory. Is that what is going to come down to? The witnesses testifying to the fact that the defendant suffered from battered person syndrome and PTSD, and he has given a complete basis for that opinion. Now, if we open up the door, if we start going beyond those boundaries and start asking him about evidence and his personal opinion and whether he thinks certain witnesses are unreliable or not, or persuasive or not, then perhaps that would open the door to what counsel is suggesting. I'm not going to do that. I'm not going to use this witness as a sounding board for a prosecution theory of the cases. I'll get a chance to argue that case when both sides finish presenting their evidence. I think counsel should reverse her argument for this time as well. I'm going to ask this witness about the basis for his opinion based on what he testified on here in court, and I'm not going to be using him as a sounding board. I don't think that counsel should be permitted to do so either. The court says, the only evidence that I can see that has any relevance in this case is the witness having listened to the tape or any other tape of the defendant's interviews with the police, and whether or not, in his opinion, this demeanor of the defendant on the tape was consistent or inconsistent with any diagnosis of PTSD, since the jury has been presented with the actual voice of the defendant on those tapes. As to the contents of them and what the defendant did or did not mean, and whether a word really meant something else, whether black is white and up is down, and things of that nature are beyond the function of this witness, and that's for the jury to resolve based upon their interpretation of those things. Ms. Abramson says, I don't think it doesn't make any sense to me to ask if the demeanor of my client on the tape is consistent. How in the world can he know his demeanor? Don't ask him. What? I think the inquiry is why this witness is not dissuaded from his conclusion by this piece of evidence. I don't remember offering to have this witness testify that up is down or right is wrong or a word means something else. The court says, well, as I recall, the way the experts testified about the interpretation of that tape in the first trial, that's precisely what they did. They took words and said it meant really something else because of their superior knowledge and education and background. What the F is this judge talking about? That's not true. And that's not even the issue right now. So what is the problem? That was so uncalled for, that comment. Good thing this is not in front of the jury. Ms. Abramson says, I haven't offered to do that here, Your Honor, and I would point out that in the first trial, the testimony was not objected to. The court says, regardless. Ms. Abramson says, so it's neither here nor there. The fact is, I'm not going to ask him to do a crossing out line by line of this tape, but just broad reasons why he does not find this persuasive or why this did not change his opinion. And I don't understand, based on what theory or rule, that the demeanor of the defendants is the only relevant part of this. And the court says, because to go beyond that is to ask the witness to form opinions as to why the tape was made, what the purpose of it was, what the motivation of the parties were, and what they said, why they said those things. That has to be decided by the jury, not the witness. And to get into that sort of evidence by this witness expressing his opinions is improper. That's really what would occur from the offer of proof. It's not improper for another mental health professional to comment on another mental health professional's interviewing style and things of that nature. It's not unprofessional. Or I mean, it's not out of the realm of what he should be doing. It should come in. It should be admissible. He continues to say that's really what would occur from your offer of proof, that he is going to put his interpretation on why people did things and why they said things. Miss Abramson is like, no, he isn't going to put this interpretation on why people did something. He's only going to say why, on the face of it, he can't rely on this, that the indicia of reliability is not there. The court says again, the indicia of reliability is derived from his interpretation of why the tape was made and what motivated people. No, it doesn't. Miss Abramson says, I wasn't going to ask him why the tape was made. The court says whether cues are missed and things of that nature. If there were cues missed, were they missed because somebody was in a therapeutic setting and should have spotted cues, or was it a rehearsed presentation where the defendants were lying about about what occurred and concurring with what it was that Oziel said, and that's the end of it. Those are things the jury has to decide, not the witness. Ms. Abramson says, when we talk about an expert witness, and particularly a psychological expert, what's important in talking to people when you're trying to evaluate or interview someone, the basic rules that have emerged, particularly in the setting, for example, of interviewing child victims or interviewing eyewitnesses, I think there are some common notions that you don't lead and you don't suggest, because if you do, you're not going to get a reliable answer. Those kinds of broad rules, I think, we should be entitled to get into. The notion, he cuts her off and says, the judge cuts her off and says, that would only apply if there was a situation where that's what the purpose was, to speak with someone and get their opinion of what happened and why things happened. But we have your client's testimony that he was lying through his teeth during that interview, and therefore his witness's interpretation of it could go no further than, yes, I accept your client's version of what happened and why it happened during that interview, that he was lying. So what does that prove? Ms. Abramson says, well, I don't believe, first of all, I think that the court has, by limiting this expert to opinions only based on the specific words that my client testified to, I think we've been unnecessarily constrained. You bring in an expert because they have the knowledge and training and skill to interpret events, particularly to interpret psychological events, and what we basically have thrust on us here is a client in his own with his own or my client is his own therapist. The only that only his particular expressions of mental state are the mental state evidence that the court has allowed us to get into, when in fact this witness could offer opinions on mental state even if they had not been specifically articulated by my client. Now, that rule is extending here to limiting the witness. I take it he's not even going to be able to do this, to limit the witness to somehow not only accept my client's version that he's lying, but to not accept the part where my client says he is beginning to tell the truth, which he testified to, that he was saying things that he knew were getting close to the truth of what happened, or that his brother would cut him off, which he also testified to. The witness doesn't need to rely on Erik Menendez's version of what's going on here for him to say, I didn't find this reliable because the method of which it's conducted, whatever the purpose is. The court says the witness is not here to vouch for the credibility of the testimony of the defendant. That's not his purpose. And if it was the purpose of his testimony, it would have been permitted. The only reason he's allowed and has been allowed at all to discuss the issue of malingering and how he approached the investigation of the matter to determine the defendant's mental state or his diagnosis was to support the credibility of his diagnosis, not to support the credibility of the defendant and his testimony. Really, that's just what you're proposing to do. Have the witness document why it is that he believes the defendant was telling the truth in his testimony. This judge is so off base. He's either completely ignorant of mental health issues, or he's trying to make any excuse in the book to not let this guy testify to certain things. Ms. Abramson says, that's not what I'm asking him to do. The court says Ms. Abramson continues and says, I'm asking him to comment on the completely irrespective of the defendant's testimony. And I was going to ask him to comment on a number of the prosecution's evidence in this case, such as the spending evidence, why the spending evidence doesn't dissuade him. I assume now I'm not allowed to do that. Why the lying to the police doesn't dissuade him, I assume I'm not allowed to do that. What I'm put in the position of having is a witness the jury will believe ignored all the evidence or had the negative evidence withheld from him, and therefore his opinion has little value. She's absolutely right. This is absolutely what's going to occur because he doesn't get to contest all the other stuff. The court says, you brought out that he had all this evidence available to him. It's all there. The jury knows it, and he's formed his opinions based upon what he said was his reasons. Ms. Abramson says, so the court is ruling then I cannot confront him with any of the prosecution evidence to ask for his comments on why it did not why it was not persuasive. The court says, I just don't see that's the function of an expert testimony. It actually is. It actually is, Your Honor. That's the ruling? She asks, like shocked. He's like, that's the ruling. Okay, I have no further questions. The court says, all right. And on cross-examination, was there some issue of he just cut her off completely, like cut off her defense with this witness. Everything that she wanted to get into, which was a lot more, he's just like, no, I don't see how it's relevant. This is totally like what's the word I'm looking for? Like they are purposely trying to destroy the defense's case. I mean the judge and the state are in cahoots to try to purposely disallow any evidence that could actually help the defense in their defense. The court says, all right. On cross-examination, was there some issue of discovery, or are you ready to proceed with cross-examination just so we don't start off with somebody needing a recess? Mr. Khan says, no, we won't. If I reach that point, I'll alert the court. I'm not going to broach that in front of the jury. Ms. Abramson says, now, I should indicate that I would therefore ask for a ruling that the prosecution cannot bring up any of the prospective evidence in this case in cross-examining this witness. Nothing. Since I've not been able to get his position on why these things did not dissuade him, I would ask for a ruling that the prosecution cannot bring up any of the matters either. I'll have to hear what the prosecution's cross-examination is, says the court. The words I would say right there, the words that came to my mind were, fuck you, judge. Just fuck you. He won't let the defense get into any of it, but I'll just have to wait and see what the state says. I'll have to wait and see what their questions are. I'm not going to rule on anything just now. Are you kidding? You just cut off her defense and basically making this witness very ineffective. And now you're leaving the door open for all the stuff that you banned her from getting into for the state to get into. How on earth is that fair? I don't understand this judge. But nonetheless, he says, all right, let's get the jury out. The jury enters the courtroom. All right, so the jury enters. The court says, okay. Ms. Abramson says, Your Honor, I have no further questions. The court says, all right, we'll have cross-examination. Mr. Khan is doing the questioning for the state, and he asks, Dr. Wilson, have you testified in criminal cases before? Yes, I have. How many times? I don't know the exact number. Well, can you give us an approximation? Oh, somewhere between 75 to 100, I would guess. What type of criminal cases were they? Broad range of criminal cases, murder capital cases, other kinds of cases as well. How many murder cases have you testified in before? I don't know the exact number. Can you give us an approximation? Number of murder cases? Yes. I'd have to guess. Just a second. Ms. Abramson said, I would object to the witness guessing, Your Honor. Court says, all right. Well, I assume by taking some time, you're not going to guess. The witness says, I can guess. I just don't have an accurate count. Court says an approximation. The witness says, I'm going to guess somewhere about maybe 25. Mr. Khan says, and how often were you called by the prosecution in those murder cases? How often was I called by the prosecution? Yes. Thinking back, I can think of one case particularly. One case? Yes. Was the purpose of presenting an opinion as to whether a person was suffering from post-traumatic stress disorder? That's correct. Did you express the opinion that that in that case that the person was not suffering from PTSD? That's correct. Would you say about the other 24 times you testified on behalf of the defense? Yes. Where was the one case where you testified for the prosecution? State of Florida. You're an expert in post-traumatic stress disorder? Yes. And in all the cases in which you testified, that is, what you said to be approximately 75 to 100 criminal cases, was that always in regard to post-traumatic stress disorder? Yes, that's correct. Do all of your patients suffer from PTSD? I only treat PTSD, correct. Why is that? That's my specialty. And how does it work out that you only treat post-traumatic stress disorder patients? Are they referred to you once they've been diagnosed as suffering from PTSD? It's a good question. I get patients in a number of ways. One, I have referrals from physicians and psychiatrists, mental health professionals in my community of Cleveland, Ohio, and elsewhere in the greater United States and abroad. That's one way. Another way is that I'm the director of the Center for Stress and Trauma, where we do have an ad in the Cleveland Yellow Pages. Sometimes the people call and see the Center for Stress and Trauma. People who have had a traumatic experience inquiring what it is that we do at the center and what kind of services we offer. That's another way in which I get patients. By and large, most of all my patients are referred to me. So the 24 times in which you testified for the defense in a murder case, in each and every one of those cases, post-traumatic stress disorder was being used as a defense. Is that correct? Yes, it was. That's because it is a valid defense, but it doesn't get you any real anything. It should get you some leniency. It should get you, instead of being a death penalty case and going for murder first degree, maybe you get, manslaughter or second degree. That's where this is important. Not necessarily in the guilt phase, because we know Eric and Lyle did it. They admit it. So it's not really about did they do it. This is about, like, they shouldn't have even had a guilt phase because they already admitted to being guilty. It should have been, it should have just gone into like, okay, what is their penalty going to be? What's the sentencing? I mean, I know that's not how it works, but they already admitted to it. So this is all basically, they're fighting, the state and the judge are fighting so hard to get the toughest conviction, the toughest sentencing, the toughest charges to stick. You know what I'm saying? They're trying so hard to get the death penalty or to get murder in the first degree versus manslaughter. When really, when we learn and we know about PTSD, when we actually take the time, Judge Weisberg, to understand what PTSD is, even though you had a trial and you had several experts explain it to you, then you'll understand that it comes down to they couldn't help it. They couldn't help it. They did the crime. They were in a position. It might even come down to, do we even charge them? But the state is like, nope, let's go for that death penalty. Anyways, next question. How many of those involved Vietnam veterans? I don't know the exact count. Many of them were Vietnam vets. Have you testified in murder cases involving domestic violence, domestic killings, which did not involve a veteran? Yes. And did you have expertise in the area of child sexual abuse? No, I don't consider myself an expert in child sexual abuse. Well, have you written any articles dealing with child sexual abuse? Specific articles in terms of child sexual abuse? Yes. I have one article that's a comparative study of different trauma groups, including people who are victims of childhood sexual abuse. Oh, how much are you being paid as an expert witness in this case? I've been paid $5,000. How many hours did you put into this case? I'm not sure the total count. As I sit here, it's somewhere in excess of 230 hours. That comes out to less than $25 an hour. That's right. And is that your normal fee? No, it's not. Can you tell us why you are working for less than your normal fee in this case? Yes, because the court set a cap on the fees. I can't get paid any more than that. That's why. Well, did you agree to that cap, or did you just find yourself on this case and having no recourse? No, I agreed to the cap. I didn't have to take this case. Okay, so once again, can you tell us why it is that you agree to work? How much is your normal fee when you see a patient? My normal fee? Yes, 125 an hour for psychotherapy. Do you have a normal fee for as an expert witness? You've testified in civil cases, I take it. Oh, sure. What is your normal fee in a civil case? Ms. Abramson says, I'm going to object as irrelevant. And the dumbass witness answers and says 200 an hour. Mr. Khan says 200 an hour? That's correct. That's for in-court testimony. Yes. And here you're working for perhaps 1/8 of your normal fee. That's correct. Can you tell us why you decided to do that? Why I decided to do it? Yes. Yeah, there are several reasons. First of all, when I was initially contacted in this case, I was contacted by Mr. Levin over there, and I've worked previously with Mr. Levin in court cases, and he asked me if I would take this case. And since I've worked with him in the past, I felt very comfortable in doing that. That's number one. Two is that I think it's an interesting case, and after I became familiar with the case, I thought it was a challenge and interesting case to take. And on how many previous cases did you work with Mr. Levin? I don't know the exact number. I'm going to guess around 10. And were they all cases involving PTSD? Yes. All criminal cases? Yes. All criminal cases in which PTSD was used as a defense? Yes. Now, you testified in a hearing that was conducted in the court some time ago. Is that correct? Correct. Do you recall when that was that you testified? No, I don't. The subject matter of your testimony was post-traumatic stress disorder. Is that correct? Yes. And the defendant, Erik Menendez, was present during that hearing? Yes, he was. And you explained and described what post-traumatic stress disorder was. Is that correct? Ms. Abramson says, Your Honor, I'm going to object to this as irrelevant and calls for hearsay. Overruled. Yes, I did. Mr. Khan says, and then it was after you explained and described PTSD in the presence of Erik Menendez that you then went to the county jail and began interviewing the defendant to determine if he had post-traumatic stress disorder. Is that correct? That's correct. Did the defendant appear to be paying attention to your testimony as you were describing what PTSD was in this courtroom? Ms. Abramson says, objection calls for speculation and conclusion. Sustained. Mr. Khan says, okay. Now, you heard testimony, or rather, you were asked questions about whether or not you were aware of the defendant having any books on post-traumatic stress disorder in county jail. Is that correct? Yes. Are you aware of the defendant having any books in county jail about PTSD? I'm not aware of that. Correct. But you do know that the defendant was present in court while you were testifying concerning what PTSD is. Is that correct? Objection, Your Honor. Overruled. Yes, says the witness. Okay, and then how long after you described what PTSD is that you then go over to the county jail and interview the defendant for the purpose of determining whether he had the symptoms of PTSD? I'm not sure of the exact amount of time. I'm going to guess maybe it was about maybe a month and a half. And do you know who else the defendant spoke to during that month and a half, that period of time? Do you know? Objection, Your Honor. Improper question. Overruled. No, I don't. Mr. Khan says, you don't know if he had access to any persons who have knowledge of PTSD. Is that correct? That's correct. How did Mr. Levin write a book about PTSD? Or did Mr. Levin write a book about PTSD? Objection, we request to approach, says Mr. Levin. Ms. Abramson says, I'd ask to approach to make a motion. The court says, okay, all right, let's go to the side. So we're going to have a sidebar here. Following is outside the presence of the jury. Ms. Abramson says, Your Honor, that question, in my opinion, constitutes the most gross misconduct by a prosecutor. He has impaled my client's Sixth Amendment right to counsel. He has insinuated that counsel has falsified testimony in this case. He has used my client's appointment of counsel, Mr. Levin, as a piece of evidence against him, just as in the Schindler case that I had once described to this court and will be happy to describe again. I am moving for a mistrial. I think that this is a violation of my client's Sixth Amendment right and going beyond the scope of any permissible cross-examination and typical of Mr. Khan's sneaky tactics. Mr. Gessler says, I join in a motion for a mistrial at this point on behalf of Lyle Menendez, Your Honor, based on Erik Menendez's status, not just as co-defendant, but as a key defense witness, and based on the obvious jointness of many of the features of this trial. I think this is egregious prosecutorial misconduct. It is suggesting that the defense team has made up their defense through Mr. Levin's particular knowledge of this particular subject, and I join in a motion. I don't have the cases with me today because I don't think this would come up. I think this court's aware of the prosecutorial misconduct cases where defense counsel is impugned without any evidence to support it. Mr. Levin says, Your Honor, I would state, since it is my name that was mentioned, I have written a book. It's entitled Defending the Vietnam Combat Veteran. It has absolutely nothing to do, no relationship to this case. There is no relevancy at all to the fact whether I wrote one book or hundreds of books. The fact is that counsel has now insinuated, I think, the previous questions with respect to why Dr. Wilson took the case was appropriate because Dr. Wilson had a working relationship with me. But then he went further, and now what Mr. Khan has left is an inference in front of the jury, coupled with that previous, perhaps, that appropriate question is the inference that I, Erik Menendez's lawyer, have special knowledge in this entire mental defense. And I wrote a book about it, and I have consulted with and conferred with my client and trained him in how to respond to issues regarding PTSD. And that is especially egregious given the fact that I conducted his direct and I was the attorney to put him on the stand. And several times Erik Menendez testified that I don't know why Mr. Levin asked me this or didn't ask me this. And I feel that it has to be taken not only in the context of the fact that it's so irrelevant whether I wrote a book. I also wrote an article for the American Jurisprudence. Is that going to come up on post-traumatic stress disorder? Court says, let me stop here. It's almost 10:02. I'll tell the jury go and we can continue this inside the courtroom. It's more convenient that way. So they go back into the courtroom. The court says, okay, first things first here, the objection to the previous question, the last question asked by the prosecution is sustained. The question is stricken. The jury is admonished to disregard it. It's about 10 minutes to the hour. We'll take our recess. We'll resume at 1:30. Don't discuss the matter with anyone. Don't form any final opinions about it. We'll ask the lawyers to stay behind so we can ask some more or speak some more, and we'll be back at 1:30. So we're going to continue arguments here. Court says, okay, the jury has left. All right, let's continue. I think, Mr. Levin, you were in the process of stating your position. Mr. Levin says, yes, Your Honor. And I also feel it's absolutely incumbent upon myself to be a witness at this point. I must testify, and I have a conflict of interest. I must testify that, yes, indeed, that I have written a book, and I must testify to what the contents of that book are. I must testify that I did not sit down with my client and go over the pages of that book in order to educate him as to how to handle the questions posed to him by myself and answer them in PTSD context so that Dr. Wilson will therefore be able to give substance to his testimony to support his mental defense. I must testify that I have not been training him for the upcoming scheduled interview by another psychologist, Dr. Dietz. I must testify that I did not coach him in any way, shape, or form. There is no other way to rebut the horrible inference that's been left before this jury. I take personal offense to the fact that although it was my client that said I was a police officer, I've been personalized in this room and I don't like it. I have never brought it up, and it shouldn't have been brought up. The jury knows far more about me than they should know, and I feel very uncomfortable now. And Mr. Menendez's attorney, and I feel horrible that I inserted myself into this case and accepted the job knowing and seeing now what has happened because I've hurt my client. My expertise in an area that I have special interest in and my involvement in this case has now caused my client serious harm. It has left an inference in front of the jury that Ms. Abramson, for whatever reason, selected me as counsel, but that knowledge and expertise that I have spent my life in working in because of my personal reasons has now been used to not help my client, but it is being used to devastate him and to hurt him, and I feel outraged. I feel embarrassed and I feel humiliated. Moreover, I feel I must continue to help my client, and the only way I can help my client now is to testify, and I don't think that's possible. Ms. Abramson says, I think the objection goes beyond that. I mean, obviously, as this court knows, a decision of a lawyer to testify has to be weighed very carefully. But the insidiousness of this line of questioning, I think, was apparent, Your Honor, when they started talking about the previous hearing, and I objected, and those objections were overruled. The court says that was proper inquiry. She says, let me tell you where it goes, Judge. The court says you brought out this inference that your client had never been exposed to the symptomology of PTSD, no knowledge about it before he was interviewed by Dr. Wilson. He was controverted by the fact that he was sitting here in court listening to the testimony. Ms. Abramson says, well, except what was the nature of that testimony? It never went beyond the psychological language that appeared on the charts that we used in this hearing, which I have presented and which we now have to get into the details of the hearing. It never talked about how things like lack of concentration in school is a signal of PTSD. I never talked about behavioral facts. The court says we've had hearings throughout the trial where issues arose as to what witness would be permitted to testify and which witness would not be permitted to testify, symptoms of what post traumatic stress disorder would be and wouldn't be. Those things went on throughout the trial, and to identify the fact that your client was here throughout all of those proceedings and heard these things and heard your offers of proof throughout as to why the evidence was, Ms. Abramson says he also heard. Wait, let me finish, says the court. That's all you're saying. You're the one who took the fact your client never has been exposed. I didn't say that. That's the way. No, says Miss Abramson. Let me finish, counsel. You're talking after me, not during the time I'm speaking. The impression you gave was your client went into the interview with Dr. Wilson completely innocent of any information at all about PTSD. That's how he became. Samerson says, well, that's not what was asked or testified to. The only thing that was asked was whether he had books, because the previous questions had to do with the research literature on post-traumatic stress disorder that is not commonly available, and that had to do with Dr. Wilson's testimony about how the consistency of the information he was given and the fact that my client did not use symptom language and did not refer to PTSD symptomology was part of what formed the basis of his opinion. Well, why did you bring out in your examination that your client didn't have books? First of all, this is the court speaking. Sorry if I didn't say that in case you're not following along. Sometimes, I like to just listen and I'm doing other things when I'm when I'm listening to streams. So that's why I like to sometimes throw in an Abramson said and the client or the witness says, because if you're following along, sometimes it gets jumbled and you might forget who's talking. The court says, why did you bring out in your examination that your client didn't have books? First of all, Dr. Wilson had no way of knowing what was in or was not in that cell. Ms. Emerson says, because he wouldn't know. The court says he would have no way of knowing. He won't know what are the factors that are considered important in the research community for making a determination of whether someone has PTSD. I understand why it's important for you to establish that, says the court. Ms. Abramson says, based on facts. The court says the question is whether or not you can prove that through the testimony of Dr. Wilson, and what is it that people have to that the people have to refute. That your client has been sitting in jail. The sheriff has no policy on books of one sort or another that Dr. Wilson is aware of. Fine. Let me finish, says the court. They have no way of dealing with it one way or another, other than through examination of witnesses trying to explore information that you brought out. Ms. Abramson says, well, if we could stop the blaming for a moment, Your Honor, so I can. It's not a question of blaming, says the court. It's a question of how the issue arises to start with. That's correct. I never said he was never exposed to any aspect of PTSD. I was present in July when he had those hearings as well. I simply asked whether there were any books, research type books that we were talking about. Now, the way to contravene or convene that is a simple question of Dr. Wilson. You've never been in his cell. That's how you contravene it. But instead of doing that, they violated the rule in People versus Schindler. They used his choice of lawyer against him. They used an inference that the attorneys in this case have now told him what to say, and I think at a minimum we are entitled to, if you want me to list the following, all of the testimony from the first trial to show that long before there were any hearings in this case about PTSD, my client testified absolutely consistently concerning his background and his thought process and his symptomology, and he did as he did in this trial. Number one. Number two, the fact that Mr. Khan, I made an offer of proof before the 801 hearing, before Dr. Wilson ever appeared in this courtroom, that Dr. Vickery had confirmed a diagnosis of PTSD, and therefore I want all of Dr. Vickery's notes admissible at this point, because those notes contain the same symptoms, the same behaviors, the same reactions of my client as he told or as was told to Dr. Wilson to overcome this misconception that people have that my client's making up these episodes now in order to fit a PTSD diagnosis. How did my camera slip or maybe I slipped? I don't know. I moved. I'm not centered anymore. Okay, that's better. Number three, we ask leave of the court to put on every corroborating witness that we have to show this symptomology is not a fiction of what my client made up to tell Dr. Wilson, but comes from dozens of dependent witnesses who saw this behavior by the parents on the one hand and by the defendants on the other over the course of these years. What counsel has done is raise a totally false issue of recent fabrication that we all have the evidence in the world to disprove, and first of all, I move for the mistrial because I don't think a Sixth Amendment violation like this is curable by striking an answer and admonishing a jury with regards to testimony. They're not going to disregard it. They're not capable of it. I cite People versus Schindler here as the case that indicates that the misuse of choice of counsel is of constitutional dimensions and requires reversal on appeal and a mistrial at this point. She's not wrong. If that's what it really says, that mistrial is warranted because they're questioning the judge or the selection of the defendant's attorneys. If the court denies that motion, so she wants a mistrial. If that's denied, I seek leave to introduce by videotape all of my client's previous testimony in order to show that there was nothing recently fabricated for this trial. Number three, I seek leave to call all of the corroborating witnesses. Number four, to introduce Dr. Vickery's notes in detail to show how all of this symptomology was reported in 1990. And I think that's the only adequate remedy for this false method of trying to disapprove a fact about a book for which all he had to do was ask a question or call a sheriff's deputy to say they don't inventory their cells, if there's what the point was. All I was trying to do is show how technical and sophisticated the interpretation of behaviors are to fit symptom categories of PTSD. And since my client never talked about symptoms, for him to be able to talk about behaviors that just would have happened to fit, he would have had to have a lot of research literature. There was nothing in those hearings that we did that talked about specific behaviors and how they are interpreted into the technical language. Thank you, Your Honor, for hearing me. Mr. Gessler says, I join in the motion for a mistrial, and I don't believe that even the measures suggested by Ms. Abramson will cure what has happened here today, even if, and I'm not conceding it is, even if it was fair game for the prosecution to ask questions concerning being here during a pretrial motion and therefore sopping up knowledge as to what PTSD might be, especially given the prosecutor's in detailed knowledge of how Mr. Menendez testified at the first trial, because certainly he has read the transcript and anyone can go watch it. And also knowing of Dr. Vickery's testimony from the trial and probably other knowledge of Dr. Vickery. But assuming all of that, and even without conceding that, the court is correct, and perhaps that question was open to rebut some inference that there were no books in the jail. But the line was crossed irrevocably when he brought Mr. Levin in, and having done something wrong, with obvious inference to the jury that Mr. Levin has made up this particular defense. He coached Mr. Levin as to how to pass the tests that were given and how to pass himself on to Dr. Wilson. And there is nothing that I can think of, even the prior testimony of all the things other witnesses, that will ever take away from the jurors that inference that we together have made up the defense. The counsel have behaved inappropriately. And as Abramson said, using counsel instead for the defendant, the use of counsel, using it against him. Even though he is Erik Menendez's counsel, there is an obvious total flow over into Lyle Menendez in this case, because if Erik Menendez made it all up, Lyle falls too. He is the star witness for the defense in this case, and I have to join in a mistrial. I believe there is no other remedy at this time where counsel's integrity has been so attacked except a mistrial. We'd have to start over. The court says, okay, let me hear from the prosecution. This is insane. Um, the court says, oh, sorry, the Mr. Khan says, yes, I felt that the question was appropriate, and I still feel it's an appropriate question because counsel opened up the door to this area. We have to get back to why this area became relevant to begin with. That is because the defense decided that they were going to put before this jury several things. Number one, the impression that Erik Menendez does not have access to books, that he does not have access to materials by which he could enlighten himself concerning PTSD, the elements of PTSD, and what constitutes PTSD. What is an indication of PTSD? If their position now is that the defendants testified to this previously, they could have elicited the fact simply by asking the witness whether this is something that he testified to previously before the witness even came on to the case. They decided not to do it that way. They decided to focus instead on the availability of materials and his access to materials. So they explored this in several different ways. One way in which they did it was by asking him about the materials that the defendant might have access to in county jail. Whether or not, as an inmate in county jail, he would have access to books, and books was mentioned specifically. This was their area that they decided to get into, and reading the literature that would be available to someone in county jail. Secondly, they brought it up in another way in which they spoke about how this is how this is material which is not commonly available. They suggested through the testimony of this witness that somehow this is an esoteric topic, that it's not commonly available to people out there, and that somehow it's only available in certain types of libraries and that it's relatively rare. I think that they went way out of their way to create the impression to the jury that there's very little of this material out there and that it's not commonly available. And what we seek to do at this time is to question the witness regarding the availability of post traumatic stress disorder materials in the forms of books, in the forms of articles, and how commonly available the material is. It's so commonly available and so well known that even one of the attorneys in this case has published a book in regard to the material. I think when they were talking about this material isn't out there, I think they were talking about how to determine if someone is maligning or malingering or whatever, feigning their symptoms. I think that's what he was talking about was, when it comes to the process of interviewing a client and learning whether a client is telling you truthful things and how you verify or corroborate the things that the client is telling you. I think that's what he was talking about, was that those techniques aren't necessarily readily available as to how to determine if someone's got PTSD. But I could be wrong. Anyways, he goes on to say, now, no one is accusing Mr. Levin of anything. No one is suggesting that that he prepped the witness or coached the witness. But if he wrote a book and that the book is available among the other material out there, which can be purchased and which can be sent to county jail and which the defendant can read clearly, he had an opportunity to read the material for himself. So I think that the defense is overstating their position. They're suggesting coaching. We haven't suggested coaching. That, I think, they protest too much. What a dick. Ms. Abramson says, Your Honor, that is just astonishing. In other words, sifting through all of that hot air, the bottom line is they cannot prove my client had access to any materials. So they just want to raise the speculation that it's, quote, out there, and that one of the pieces out there is a book that Mr. Levin wrote, and that there's no harm in pointing that out. Now, it's total speculation. They have absolutely no way of proving that my client had access to any books concerning PTSD and the question that I asked was whether he was aware of him having any books on PTSD or child abuse. And this is same line of questioning that was used in the previous trial and did not result in these prosecutors in so egregious a violation of my client's rights. However, obviously, Mr. Khan can't prove otherwise, so he wants to raise this high speculative panoply of how many books and articles are out there. It's totally irrelevant what's out there. It's even irrelevant what Mr. Levin wrote, unless the people are in a position to prove that my client had Mr. Levin's book and the material in the book informed his testimony. They tried the same tactic with Paul Mohn's book in the last trial, and the objection to the tactic was sustained. The people there, too, were unable to prove my client was fed any information from which to form the basis for his testimony, and this is even wilder and more speculative and a specious excuse for injecting counsel and improprieties. Am I saying that right? Improprieties by counsel into this trial. For some reason, it wasn't sounding right to me. Anyways, Mr. Gessler says I join in that, Your Honor, and take exception to the prosecutor's explanation to the court that they were trying to do, what they were trying to do was show there's material and books out there. If that's what they wanted to do, they could have asked that question instead of tying Mr. Levin into it by personally naming him and having him author this book on the subject, which, number one, is not true. Number two, as we know, he's a wounded war vet in Vietnam who has taken a great interest in PTSD because of what he has seen, experienced, and felt, tying him in as to having worked with Dr. Wilson on 10 prior cases which involve Vietnamese war veterans and defense of PTSD in a totally different context from this particular case. And then talking about him having written a book personally is obviously to lead to only one inference, and I expect it's been drawn by all the members of the audience who heard it before our colloquy here, and before all the jurors, which is that the defense team engaged in misconduct in trying to help with the defense, coach with the defense. Otherwise, there was no reason to bring Mr. Levin's name up to this particular witness as having authored something and worked with him. The court says, okay, as I stated, the general subject was brought up by the examination of Dr. Wilson and by Ms. Abramson. That by itself doesn't resolve this dispute, but the nature of the examination by Ms. Abramson was designed for a purpose, and I believe it misstates that purpose to say nothing more was meant by it than the words that were asked. The purpose was to convince the jury that the defendant had not had any access to materials during dealing with symptoms of PTSD, and the prosecution was in a position of responding to that during the cross-examination. The issue of the cross-examination and the direct examination is to establish or discredit the validity of Dr. Wilson's diagnosis and opinions. His opinions were based to a great extent on his interview with the defendant. He spent a great deal of time in describing the manner in which the defendant responded to the various questions that were asked, the evolving process in which the interviews were conducted, and Dr. Wilson also indicated that he referred to the former testimony of the defendant from the first trial. That reference to the defendant's former testimony is already before the jury, and follow-up questioning by Dr. Wilson to document that the defendant has already testified in the first trial to the same symptoms that he has described in his interviews with Dr. Wilson would refute the inference that the prosecution seeks to establish that the defendant had recently fabricated the symptoms based on a need to prepare for his interview with Dr. Wilson, plus reference to the various source witnesses as described by Dr. Wilson who described the various symptoms. That's how that issue is addressed, not by testimony of counsel or testimony from the first trial being introduced to resolve the issue, but the fact that the witness, in support of his opinion, referred to the testimony from the first trial. Again, the purpose of the examination of Dr. Wilson is to either support or attack his credibility, not the credibility of counsel, not the credibility of anyone other than Dr. Wilson and his opinion as to what it was based upon. The general nature of the inquiry that was conducted by the prosecution was a proper response a proper response to what it was that was brought out by the defense in its direct examination of Dr. Wilson, that is up to the point of questions regarding Mr. Levin's authorship of a book. It's unclear to me, number one, what is in the book and whether Dr. Wilson has read the book, and as to whether or not anything in that book has descriptions of symptoms of post-traumatic stress disorder to start with. Number two, and I bring that up for the purpose of how it is that there would be a response by the defense to the inquiry. If the book had nothing to do with symptomology of post-traumatic stress disorder, then very simply a question asked and answer given in that regard would deal with any inverse inference that was brought out. Are you kidding? That's it. That's how you remedy that, according to the judge. The fact that the prosecution has no ability to prove that the defendant had access to the book or that he had the book, it is the court's view that the objection to the prosecution's questions should be and was sustained, and that the question itself is stricken and the jury has been admonished to disregard it. I don't find that the question itself being asked has caused any prejudice in this case. Of course not. Of course he doesn't find any prejudice because he wants to have it inferred in front of the jury that, maybe the defense is a little off kilter here. And that is, he says he doesn't find anything that could cause prejudice in this case that is not cured by the prompt objection and the court's ruling upon the objection by sustaining it and striking the question and the admonition to the jury. I don't think there's any adverse inference that is to be drawn by a mere question. But because the prosecution cannot establish that the defendant had access to this book, then the inquiry along those lines is foreclosed. Mr. Levin says, Your Honor, may I be heard on one point? Yes, says the court. Mr. Levin says, I think what the court is saying, and correct me if I'm wrong, there's an additional event that must occur in this courtroom to cure the inference that may be lurking now within the minds of the jurors, and that is prospective questioning of a follow-up nature by the defense to cure what harm that may have occurred from the prosecutor's egregious misconduct. In essence, the court is directing the defense to ask specific questions of the witness in prospective questioning to clear it up, invading the province of not only the defense's obligation to determine what strategies and what questions should be asked of witnesses, but we don't feel it's incumbent upon us to fix anything. The prosecution has, I believe, done a lot more than what the court is finding, and I am extremely sensitive of, number one, my Sixth Amendment obligation to my client to use every zealous means to defend him, including my background, my experience, and all those things that lawyers do in every other case, and not have it used against my client without at least having counsel approach the court. He got every opportunity, if he so wishes, to tell the court he's going to do something of a controversial nature. He never does, says Ms. Abramson. Mr. Levin says, and had this court heard what Mr. Khan was intending to do, I don't think the court would have allowed it uh, to have been done because of finding a prejudice that might have occurred as a result of the question. I think we have to go back to the nature of the question. And the question was designed to elicit an inference. It was not designed to elicit a response. And the inference before the jury is that I was selected by Ms. Abramson because he knows about post traumatic stress disorder. I was selected by Ms. Abramson, who told the jury in opening statements that I would do the direct on Erik because I know about PTSD, that I selected Dr. Wilson because I know about PTSD. And now we have a linkage we have this strange web that's been established by the prosecution between Dr. Wilson, myself, and my client. And I think that everything was appropriate, I mean, arguably so, up until the point he connected me to that particular issue. The fact that he asked Dr. Wilson about his testimony that establishes an inference that Erik Menendez was exposed to it. That puts the jury in a mind frame of, yeah, now what was it that Erik Menendez would have been exposed to concerning post-traumatic stress disorder to make himself more presentable to establish credibility. We want to see how he responds and answers questions and how he handles Dr. Wilson's interview and how he responds to Dr. Wilson's tests. And moreover, which is really important, is how Dr. Wilson assesses Erik Menendez's credibility. All of which, while the jury is in that context, here comes Mr. Levin and his book. And that's the only way that the jury can take that. That's the only reason that it was offered, and that's improper. And I just cannot, for the life of me, figure out a way how to cure that. There's no way in which the court can possibly cure the defect that's occurred. I tend to agree with the defense on this one, that it's like putting the genie back in the bottle. Well, I guess genies supposedly do go back in the bottle. It's like putting the toothpaste back in the tube. You can't. It's impossible. So he goes on to say, and how I feel that there's nothing else that can be done except to offer testimony about what's in my book. Mr. Khan has raised the specter of not only me coaching Erik Menendez, but that the content of my book is relevant to these proceedings, and I need to tell the jury that it's not. Mr. Gessler says, I join in those remarks also, and I want it perfectly clear to the court. If I haven't said so before, my motion for mistrial on behalf of Lyle Menendez is based on 6th Amendment grounds and 14th and 18th Amendment of the United States Constitution, that the defense role of attorney has been so compromised by that question that there is no answer except a mistrial at this time. This is based, again, not just on the idea that there's books out there or something that might have been available to Erik Menendez, in addition to listening to Dr. Wilson testify at a pretrial motion, but the bringing in of the name of Mr. Wilson as an author in this field, having written a book. That's where the line was crossed and why it's no longer possible to have a fair trial. Ms. Abramson says, Your Honor, I just want to make it clear that my motion is under the 6th and 8th and 14th Amendments as well. I'm frankly quite appalled, although the court called me on the carpet for using the word smartass when Mr. Khan repeatedly behaves like a smartass and brings out evidence that should have been approached and should have been determined in advance. There is never a penalty or a sanction. He is an experienced prosecutor. He knows what potential 350 and 1101 type evidence is prejudicial. Yet he never seeks permission before he blurts something out, and he never is punished for it. The court says, all right, personal assaults on counsel with disparaging name-calling will not be permitted. And regardless of your feelings, Ms. Abramson, if you can't control the words you use, you will be held in contempt. Although the contents of what you say and the nature of your arguments are always of interest to the court, but the words you use and how you use them, if they're a personal attack on counsel, which they tend to be, they won't be countenanced. Mr. Khan, Mr. Khan, your response? Mr. Khan says, I think that Mr. Levin's remarks are significant because it's becoming clear that what they are arguing now is something which goes way beyond the question of the book. That is, Mr. Levin is talking now about a relationship between himself and the witness, a relationship which was brought to light by the fact that this witness was selected by the fact of their prior relationship and by the fact that Mr. Levin was brought on this case. All of those facts tied together all have independent significance even apart from the question about the book. We're really no longer talking about the book any longer. What we're talking about is the fact that before I even asked the question about the book, what we learned from this witness was the fact that there's a witness who has an experience, who has an expertise in PTSD. Mr. Levin also has expertise in PTSD. That came out through the fact that this witness referred to counsel as someone who he worked with in the past on 10 prior criminal cases, all involving PTSD. I know counsel is suggesting that the jury knows that he was brought in for this case. Well, if you put all the pieces of the puzzle together, and if there's an inference there of an overly cozy relationship with which has implications, they're independent of any questions concerning the book whatsoever. This witness puts down on his CV, he puts Mr. Levin down in his CV as someone he has worked with in the past. I think all of counsel's comments about how now his integrity has been brought into question were all present, all of that structure, all of the framework was there before even I asked the questions in the book or about the book. So the book is totally irrelevant at this point. Whether or not he wrote a book about PTSD doesn't undermine or refute the facts that were established before I even asked the questions about the book. Finally, in regard in response to counsel's question or proposed admonition about asking controversial questions, I think if counsel were to indicate to the court every question that she were to ask that were controversial or subject to objection, she would have been able to ask many of those questions that she asked this witness, all those improper questions under Penal Code Section 29, which were stricken and stricken and stricken and stricken. And as they say, well, perhaps if the prosecution has a question as to the propriety of a question, he should come to the court and ask the court if it's a proper question, that would be a two-way street, which would have applied to Ms. Abramson, and a number of those questions which she attempted to present to this witness wouldn't have been permitted in the first place. I think it's clear that there are times when the other side is going to feel that counsel has asked a question that is, in their view, inappropriate. That's inevitable. There's no getting around that. Counsel is proposing one way, a rule in which the prosecution would be precluded from asking a question that might ultimately be sustained as objectionable. Well, it has to be a two-way street and not a one-way street. Mr. Gessler says, Your Honor, this has nothing to do with the objection ultimately being sustained. Mr. Khan, in his own remarks, has admitted his questioning was totally irrelevant. He says, let's just disregard the book. Well, it's a little late to disregard the book, which was in a relevant question he didn't need to ask anyway, by his own admission, because he already had all he needed to try to set up the final argument. Again, if it simply was done to attack counsel, and that is why that is a Sixth Amendment violation justifying a mistrial. Ms. Abrams says, as Your Honor, the inference that Mr. Khan's, the way he thinks is rather interesting, but it would be improper to lead a jury into thinking the way he thinks, which is the fact that a lawyer has utilized the services of perhaps the most renowned national expert in a particular field 10 times because he is the most knowledgeable is somehow a sinister connection that bears on the credibility of the witness, of the client, and of the lawyers in this case. I mean, that is a very sick way of thinking. Think that if you use an expert over and over again, it means something bad is afoot. So I feel that he shouldn't have been permitted to ask those questions at all about prior use of his experience by Mr. Levin in PTSD cases. If it's being asked to raise this distorted interpretation that Mr. Khan wants to put on, on it that if you use the expert, there must be something wrong, instead of the fact that you simply call upon the person who's best able to make a determination. The court says, let's get off that. That's obviously a question that could be asked to show bias on the part of the witness. Let's focus on the issues here. That's a proper question. Ms. Abramson says, now the court cuts her off and says, the fact that a witness has worked with the same lawyer over and over again and gets more and more cases from the same fellow lawyer is certainly a fact the jury can consider as to whether or not the witness is giving testimony that the lawyer likes and gets hired again because of that. That shows bias. Ms. Abramson says, he wasn't hired by Mr. Levin, he was hired by me. I've never worked with him before. I prepared him, not Mr. Levin. I was the one who did all the work with him. It's just an improper inference. The court says that's not how he testified he got the case. Ms. Abramson says he didn't testify how he got the case. The court says he got the case because of his friendship with and having worked with Mr. Levin. Ms. Abramson says that's how he got involved in the 801 hearing. It wasn't broken down. The court says you keep getting sidetracked in non-meritorious argument. What you're talking about now. Getting back to what Mr. Levin said, I'm not dictating what you should do. I'm finding there is no prejudice from the question asked. If there was something further the defense wanted to do in that regard, you could have the witness reference the defendant's testimony from the first trial, reference to the fact that he saw it on tape. He's read it. He's already referred to Vickery's notes. Vickery has been indicated as a defense witness in the case. Those things are all dealt with by reference to those matters already having been made, or Vickery's testimony, proposed testimony in this matter in the future in the defense case. As far as my reference to the contents of the book and how one deals with that, I only meant that if the defense needed to go further in that regard, or felt a need to go further in that regard, certainly it doesn't require Mr. Levin, as the author of the book, to say what's in the book. If the witness has read the book, if Dr. Wilson has read the book, and if the contents of the book have something to do with defense response to the nature of inquiry so far by the prosecution, then the appropriate way of dealing with that would be through questioning of Dr. Wilson, not the testimony of Mr. Levin. But I'm not saying there is any need for that. I'm just saying that in response to the defense proffer of Mr. Levin is a witness here. Getting back to the substance of this hearing, there is a motion for mistrial by each defendant based upon misconduct of the prosecution derived from the allegation that the question asked of the witness referring to Mr. Levin as the author of a book is prejudicial. The court has ruled that the question is not prejudicial. The question itself was not prejudicial, with reference to the book was not prejudicial. Mr. Levin's authorship of the book and the question was not prejudicial. The question has been objected to, the objection has been sustained, and the jury has been admonished to disregard it. The court finds that that's the appropriate remedy for this question that has been asked, and because of that, there's no basis for a mistrial. Of course not. Therefore, the motion for mistrial on behalf of each defendant is denied on all grounds stated. I'm sure he's going to deny all the other things that Ms. Abramson asked for in the beginning, too. Mr. Gessler says, in that case, Your Honor, I then ask that without giving up the motion for mistrial, because I still feel that it is the only effective motion to make to cure the harm that we feel has been done in this case, I ask the court to cite the district attorneys for misconduct in front of the jury for having asked that question, which, as he knows, was irrelevant and has said so. And I also ask for a Bowdoin admonishment from the court informing the jury there is absolutely no evidence and no hint of any misconduct by any of the no evidence and no, sorry, I just reread the same sentence twice. There's absolutely no evidence and no hint of any misconduct by any of the defense counsel in this particular case, and whatever other words in the admonition seem appropriate to the court to try to cure the error. Is he going to do this? I doubt it, but it would be nice. Which I do not believe can be cured, but at least as to the discrepancies in this direction. The simple idea of objection sustained, jury admonished, does not carry the day when a question such as that, impugning the integrity of the defense counsel, has been expressed in front of the jury, particularly just before the noon recess. I think we need to go further. And I'm also, Your Honor, renewing the motion for severance at this time so that at least Lyle Menendez can start over with a new jury where we are not hampered by this particular question and answer, or question at least which impugns co-counsel. The court says, okay, that latter motion is denied. If you have any particular requests for admonitions to the jury, in addition to those already given to the court, you may present those to the court in writing, and you can do that this afternoon. Thank you, Your Honor, says Mr. Gessler. The court says, all right, we'll be in recess. Ms. Towery says, can we have until 1:45? We're going to need to go back and draft the admonition. The court says, sure, 1:45. So now they go to lunch or break. They probably don't eat much. If they do eat, they're eating on the fly because they're doing something else. In this case, they are writing up the admonition that's going to go out or that's going to be said in front of the jury, which is awesome. So he actually did allow that. He just, why am I struggling here to highlight? I don't know why I highlighted that word because I said it. So now I forgot what I was saying. Anyways, it just seems like, again, the judge and the state seem like they're in cahoots. What I was saying was I'm surprised he's allowing an admonition in front of the jurors that will be basically, an admonition is like shame, 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 like you shouldn't have done that type of thing. So he's going to do that in front of the jury to the prosecution to say, Mr. Khan, shame on you. So we'll see how it goes once we come back from lunch. So that's going to be in Sunday's episode. So thank you guys so much for watching. I really appreciate it. And yeah, that's all I think I have for you guys. So thank you again, all of you, for participating, watching, viewing, sharing your thoughts about this case. What do you think about the way that the court and the state are acting together? It seems almost like they're in flow with one another, right? And it's like the two of them against the defense. And that sucks because the judge gets the final say and he's against the defense. So most things that the defense wants, they don't get, apparently. And that is how life goes. But this, I think, should have been a mistrial, or definitely an admonition, if not more. And I wonder if they argued in their appeal about this particular instance. I bet it's in there because this is pretty bad. Pretty bad. All right. Anyways, that is all I have for you today. Thank you guys so much for watching, and I'll see you in the next one. Bye now. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.